Good morning, everybody. Happy Friday Eve. Welcome to the Courtroom Files Live. Let's start our day with Judge Simpson.
Okay, I set so that the record is clear, because I don't know when it may have gone down, but I set the preliminary examination for October 28, 2025 at 9 a.m. Counsel then approached regarding a change for bond case. Rather than, because of the nature of some things, rather than placing anything on the record, what I've advised counsel is there's something that needs to be checked into regarding a hold that he may have in another county. And so I'm going to deny the request at this time. Certainly you can raise it before Judge Washington.
Okay.
At the time of his preliminary examination, or if you want it heard before, then you can bring it back before me.
Okay.
Either way. All right.
Thank you, Judge.
At this point, I'll deny his motion.
Okay.
Thank you.
Thank you.
Court calls the case of the people versus Mohammed Abdullah.
Last name.
Abdullah,
Or
or is it Abdullah Muhammad?
Good morning, Your Honor. Dan Garrett on behalf of Mr. Abdullah. He's on Zoom. He lives out of state.
Okay. Sir, can you state your name, please?
It's Mohammed Abdullah.
Okay.
Your Honor, explain to Mr. Overwater, there's a little bit of discovery we still need. Can we have a 2-week adjournment if possible? For a PCC?
Got it. Probable cause conference will be adjourned to the 30th. October 30th, 2025, 9 a.m. Bond will continue. And Mr. Aaron, I'm in the middle of drafting that over for your wife.
Deputy Allen said he wanted one.
Well, they're both getting it.
Good.
Specifically outlining they have free reign. Because I'm not going to that other side. Court calls the case of the people versus Taiwan felon.
I should call this for people.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Taiwan Phelan.
Phelan. All right. So, what are we doing?
Sitting for exam, Your Honor.
All right, discovery is complete.
Yes, Your Honor.
People have their witnesses available the 28th. Preliminary examination in person, October 28th, 2025, 9 a.m. That's before Judge Barr.
Judge, Your Honor, I have a sentencing scheduled in Detroit that morning. I can probably be here by around 10 or 10:30 if that's okay.
Well, I'll set it for 9. You might want to just give Judge Barr's office a heads up,
I will do that.
and
I will do that.
I think they'll be accommodating, but
I will do that.
bond will continue. Thank you. Court does call the case of the people versus BJ, is it Udell?
Morning again, Your Honor. Dan Garrett on behalf of Mr. Woodell, who's stepping forward.
Your name, sir?
Your Honor, asking for an exam date. Discovery is complete.
All right. People have their witnesses available the 28th. Preliminary examination in person, October 28th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Andrew Travis.
Assistant Prosecuting Attorney.
Brian Bowling on behalf of Mr. Travis, Your Honor. How you doing?
Good.
Andrew Travis, Your Honor.
Thank you.
Your Honor, we're asking for an adjournment in this matter. Some additional discussions with our client and hopefully being able to try to resolve something with Mr. Overwater, even though that might not happen, but I'd like to take another shot at it. Thank you, Judge.
Probable cause conference will be adjourned October 30th, 2025, 9 a.m. Bond will continue.
Thank you, Judge.
Thank you, sir. Court calls case of the people versus Kyron. That's how I pronounce it, Newburn.
However, on behalf of Mr. Newburn, who's approaching the podium now. Mr. Newburn, please state your name for the record.
Kyron Newburn. Thank you.
Morning, Your Honor. Today's date and time set for probable cause conference. It's my understanding that people have shared all of the discovery that they have in their position. We are asking for a exam date.
People have their witnesses available the 28th.
We will do our best, Your Honor.
Preliminary examination in person, October 28th,
I think,
2025, 9 a.m. That is before Judge Barr.
thank you, Judge.
Thank you. Bond continued. Court does call the case of the people versus Aaron Hudge Peterson. Kicker?
Nope.
No.
No touch. No touch. There's no touch.
I don't know about
Nope,
Garen.
she knows.
I
No
don't know
touch.
about Garen these.
She'll confirm.
He
No.
shocked me yesterday, so
Yeah.
How are you? Your name, sir?
Aaron Hudge Peterson.
Thank you.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Aaron Dan Garrett on behalf of Mr. Hudge Peterson. Your Honor, I'm asking to adjourn probable cause conference. Last time we were here, I approached with APA Banis. Your Honor indicated you would sign an order releasing Mr. Hudge Peterson to an inpatient treatment program. We just got a bed for him. I've got a letter. I shared that with Mr. Overwater. I do have a proposed order that would allow his release, if Your Honor would consider that.
I will, to inpatient treatment, I will sign that. order.
Sounds good.
I'm not
Let
gonna.
me submit that now or just through Your Honor's court after the docket.
If you've got it, have you seen it?
Great. Sounds good.
Thank you.
Thank you.
Your Honor, will he be under any supervisory conditions as a condition of bond? I would ask at least to be. Yes.
Don't have any objection to that. The only concern is timing. I know they have a bed right now and I don't want him to lose that, but I will defer to Your Honor on that.
So I'll just say.
I think we put in there, Your Honor, I'm sorry, I'm talking while you're writing, that he would turn himself within 24 hours because they won't pick him up.
Yeah.
But if he needs a tether on, he'd just have to get there as soon as that happened.
I'll just add the language, he's to be placed on a GPS tracking tether prior to release to treatment.
Sounds great.
And I'll sign it. All right. So I'll sign that order. I'll adjourn it out. How much time did?
Your Honor, I'll ask a little bit farther out on something like that.
Something about 30 days maybe,
Please.
and let's see where he is at that
That'd be
point.
great.
All right. So I'll adjourn probable cause November 13th. 2025, 9 a.m. Bond continued.
Thank you very much.
All right. Good luck to you.
Thank you,
sir.
Your Honor.
Thank you.
Court calls case people versus Lydia Bevere Whitfield. Where is he? Can somebody get Mr. Quinn?
Good morning, Judge. Christopher Quinn, appearing on behalf of Ms. Whitfield.
Your name, ma'am?
Lydia Bevere.
We'll just set this for exam. Judge.
Is discovery complete?
Well, Alan said,
we have 2 weeks to adjourn before?
okay, that's
You
fine.
don't have all discovery?
No, I do not. So we'll set it for PCC, Judge, again.
Pardon?
Another PCC, I guess. Right, yes, that's fine.
October 30th, probable cause conference, October 30th, 2025, 9 a.m. Bond will continue. Thank you, ma'am.
Good morning once again, everybody. Excuse me. Happy Thursday. Welcome to the Courtroom Files Live. There is a cornucopia of things going on this morning. Lots of courts already up and running. Kind of abundance of riches here. Let's do something we haven't done in a while because we don't often get to. Let's stay in the area, but we're going to go over to Romulus, the 34th District Court. Excuse me, Ellie. Judge Oakley Let's say good morning to him.
Ms. Hanson, are you going forward today without an attorney? All right. It is my understanding that you're going to plead guilty to 2 charges of no valid operator's license on person. The prosecutor wants me to dismiss 1 drove while license suspended charge from January 20th and 1 from November 23. Is that correct? Okay.
Good morning.
Good morning. Did you read your rights form? You understand those rights and the options they give you? You understand the possible penalty for the charges? Understanding all of that, are you pleading guilty freely and voluntarily to these 2? All right, let's start with November 23, 24. Did you drive a vehicle in Van Buren Township while your license was suspended, revoked, or denied? I'll accept your plea on that one. January 20, 2025, did you drive a vehicle in Van Buren Township while your license was suspended, revoked, or denied? You understand that these, when these charges hit your record, the Secretary of State is likely to resuspend you.
Oh, I did not know, but now I do.
All right, what is the status of your license? What do you have to do to get, you owe money? What's the problem?
I say Airbnb, haven't had my license for the last 6 months.
Okay, so they're probably gonna resuspend it for some period of time because of these. Are you working? Where do you work and how long have you been employed there?
Is that true?
Who do you work for?
Right.
What do they do?
We have contracts with, and cash call regular zone.
Got it. Anything else you want me to consider before I sentence you?
Get a better price you can. Other than that, I'm just trying to do my best.
All right, one file you've posted $150, correct?
For the warrant, both warrant, please.
I think some of that went to a civil infraction.
I just came in, I think last Thursday, but I thought that's when my court date.
Right.
Paid, 130 for the other one.
Yeah, it looks like you took care of a no proof of insurance and a defective equipment. Did you pay those?
Yeah.
Yeah, so all your money's not on these files. Some of your money went to close those files. You follow me?
6 months.
All right, well, I'm only showing one bond of $150. You got anything that I'm not saying?
Just did it like 4 days ago.
The 272A file, the 2025 file, she posted $130 on it.
Okay, all right, so 130 on one, 150 on the other, is that right? All right, anything else? All right, on each one of these files, fines and costs are $300. Your bonds will apply. Can you pay the balance today, or do you need to work something out?
Payment plan would appreciate it.
All right. All right. Go downstairs and set that up at the counter. You're welcome. McClendon?
Sadly, team on behalf with Mr. Earnest's pleasure to extraditing free trial. She told him to seek expedited.
Good morning.
She grabbed, set the show cause or free trial, I'm sorry. I guess they let.
I don't know. Doesn't matter.
Got about 5 different dockets committed today, so if there is any warrants, we ask anything to be recalled at this point in time, you can point here and done short. We have reached a resolution in this matter, Your Honor. The pending driving while license suspended will be dismissed and determined to be tendering a guilty plea to no operator's license on person. And the civil infraction on the B case, the traffic signal will be dismissed.
All right, and the warrant, there's a warrant file on a Romulus file today. If you ask, Angela might be able to take care of that today.
Is it on this? So it's
I've got 2 Drobo licenses. I got a Van Buren that had the civil infraction, that's the plea agreement, and then I've got another one that's just a warrant status Romulus case,
Okay.
which is not on the docket.
Okay. I didn't know if because Dave's sitting over, I got Dave's pleas on the docket. He's running right now with Judge Martin. So I just didn't.
Are they both on the docket?
Who are we on? And
No, it's okay.
McClendon.
London, we have Ernest, we have 2 files.
Okay, because I've only got one on a plea agreement.
I didn't.
Yeah, this will be traffic control.
Yeah, that's this, yeah, but that's all you got is one misdemeanor, one civil infraction? Yeah, so the Romulus case is not on the docket. It's in warrant status. So let's take care of this one. I'll let you go talk to Angela and see if you can take care of the Romulus one as well. I'll leave that one there. All right, Mr. McClendon, you discussed your rights and options? Understand all that? Do you understand the possible penalty for the added charge? Are you pleading guilty to that charge freely and voluntarily today? Did you drive a vehicle in Van Buren Township on August 19, 2025? Was your license suspended, revoked, or denied at that time? I'll accept your plea to the added charge. I'll dismiss both the original charges that were issued on August 19th. What's the status of the license now? Just, you owe money? All right, are you working? Where do you work?
Yeah.
What do they do? How long you been there? Good. Anything else I should know before I sentence you?
Just that, yeah, as you said, making admirable steps to try to get this whole thing wrapped up. And not have to worry about who's in the rear view mirror.
Yep. All right, looks like you have a total of $1,200 that you owe us on other stuff. Are you on a payment plan now? Are you in a position you can commit to some regular payments? All right, so today's file is not part of that 12. Today's file is $500 fines plus court costs and 4 days on the court work program. So go downstairs, set up a payment plan, get started on some kind of monthly, regular, weekly payments, whatever you can do, and schedule 4 days on the work program. You pick the days. Any questions? Good luck. We'll see you again in a minute, hopefully. I've got the file right here. Sullivan, Dylan.
Thank you. Attorney Josh, I have everything on behalf of Mr. Dylan Sullivan, basically in the free trial. The way forward will be the arraignment stand view. As partner plead not guilty. Mr. Sullivan, please put your name on the record, sir. Dylan Sullivan.
All right, final pretrial complainant to appear.
Is Stephon Johnson. The only other thing we have to address is the no contact between now and this court date.
What time you want to, what time you want to do that on the 4th, Heather?
I'm with you guys that day, so whatever makes it easiest on the docket.
8:30? All right, you're working?
Yes.
Where do you work? How long you been there? All right. What's the complainant's name? Do you know?
Stephon Johnson with an F. S-T-E-A-N. Last name common spelling Johnson.
All right, Mr. Sullivan, is that a gentleman you know, or is that a stranger to you? So is there any reason for you to have contact with him? I'm going to put you on a personal bond. First condition is the obvious one, stay out of trouble. Second one's pretty obvious, show up in court December 4th. Third one is no contact with Mr. Johnson. No phone calls, no letters, no social media contact. You see him at Taco Bell, you're eating at Burger King, no contact. Understood? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you screw that up? Any questions? No. You can put your hand down. You owe us $882 on some civil infractions. Are you in a position to set up some kind of payment plan?
Yes.
Do that today before you leave the building? All right. Good luck.
Thank you.
Raymond McKinney.
All right. Hey, Your Honor, for the record, Jeffrey Bowden, appearing on behalf of and with Mr. McKinney. Sir, Judge, your name, please. Raymond McKinney. Thank you, sir. Your Honor, today, the balance of the arraignment in wait for me to stand here. We've also had a chance to process invitations to adjourn this matter. We have no objection. I believe she has designated November 20th. We have no objections to that.
Time, Heather?
8:30.
All right, you'd wait for Maureen, you said? I'll enter not guilty plea. Are you working, sir? Where do you work? What's that? What do you do?
I'm the service agent.
What do they do? Automotive stuff? How long you been with the company? Where'd you work before that?
USA.
How long were you with that company? Good. All right, I'm gonna put you on a personal bond on this one. First condition is the obvious one, that you stay out of trouble. Second one, you show up in court on November 20th at 8:30 in the morning. Can you do that?
Yeah.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you mess up on bond? Any questions? You're all set.
Your Honor, we get notice today.
Yep, just a few minutes.
I believe there's also a no contact order, to be.
Not on any paperwork I saw.
I've explained to him.
Brianna Lindsay.
Ready, Your Honor? Your Honor, for the record, Jeff Dodds,
Good morning.
And Your Honor, today's date, time set for ranking and Spanish, the road formal meeting schedule. Also had a chance to pre-trial this. You have executed here, subject to court approval, and I agree with this, Lindsay's going to be in charge of retail fraud. With the understanding the matter will be taken from a 7 month for a period of 6 months. The understanding being, if she complies with all the court's wishes at the expiration of 6 months, there may consider dismissal of these charges. There is restitution, paid $51.81.
5181?
Yes.
Thank you. Ms. Lindsay, did you discuss your rights with counsel?
Yes, I did.
You understand those rights and the options they give you? You understand the possible penalty for today's charge? Understanding all of that, are you pleading guilty freely and voluntarily today? On June 25, 2025, did you try to take some merchandise from a store in Van Buren Township without paying for that merchandise?
Yeah.
All right. What store was that? Walmart? What was the merchandise? Satisfied, Mr. Bowles? So am I. What should I know before I sentence?
Your Honor, this was a one-off deal for Sarah.
All right.
She was leaving for Florida, Your Honor. She'd have a bunch of them. No excuses.
All right. Are you working, Miss Lindsay? Where do you work? How long? Okay. All right. And no prior history. So this is not normal behavior for you. What was going on?
I lied in my basket of these things, so I'm honestly may have this that I
All right.
I'm really not even sure what item it was, but I'll feel like $500 if I have it right for the next day, so.
All right. Anything else you want me to consider? I'll delay sentence for 6 months. During that time period, stay out of trouble, no new criminal offenses. Court costs are assessed the amount of $350 plus the $51.81 for restitution. Can you pay that today?
You wanna?
No, the $401.81. Make plans downstairs. You also owe us $900 on other files. Just get it all rolled into one. All right, good luck. Deshaun Sewell?
Your Honor, for the record, everybody, hearing on behalf of Certainly, no,
Thank you.
Your Honor, today's date time set for writing in this matter, but may full standing. Also had a chance to pre-trial this case, we have an executed plea brief. Subject to court with an agreement, Mr. Sewell, we plead guilty to the added count, allowing an unlicensed driver throughout vehicle with the understanding the original charge would be dismissed.
Sir, did you discuss your rights and options with Mr. Bowditch? You understand those rights and the options those rights give you? And do you understand the possible penalty for the added charge? Understanding all of that, are you pleading guilty to that charge today? Are you pleading guilty freely and voluntarily today, sir? Did you drive a vehicle at or near the airport on August 17, 2020? Was your license suspended, revoked, or denied at the time? I'll accept your plea, dismiss the original charge. What's the status now, Mr. Bowditch?
Your Honor, is, this is a 5-year-old case. But he has been working through the court systems. He has a couple to go before he gets his license.
Good. You working? Where do you work? How long you been at Amazon? When are you going to get your license back? Any idea? So it's just a matter of paying the money off? Okay. All right. So generally speaking, I'm going to order 4 days work program in this charge. That means you have to be here 4 days at 8 o'clock in the morning. If that's setting you up for a failure, I'll give you another option. You schedule the days. Yeah, you don't have to do 4 days in a row. Can you do that? You sure? All right. All right, on the file, what do we got? All right, fines and costs $555 and 4 days on the court work program. Can you pay that today or do you need options? Set that up downstairs when you set up your work program. Any questions? Good luck with your license. Is it Desera Shaw? Shaw?
Right, Your Honor. Your Honor, for the record, that you're about sharing on behalf of the big ma'am, she says everything correctly. That's the right. Thank you, ma'am. Your Honor, today's date for violation of probation in this matter. I believe Ms. Shaw was sentenced maybe around February.
Yeah, early February.
She was supposed to do 10 hours of community service. She has completed none. So we're pleading guilty to the violation. We've had a nice talk. She promises now, if the court is willing to extend her a little mercy, she'll have everything done by the end of November.
What was the problem?
Well, she had school. She's just now graduating and getting up some free time.
Where'd you finish school at? All right. Well, now you've got a retail fraud conviction on your record, which I'm assuming you didn't have any convictions before. All right. 20 hours community service. And I'll give you until December 1st. Actually, I'll give you until January 1. Good luck.
All right, we'll keep an eye on Judge Oakley, but let's head down to Florida and say good morning to Wade Mercer.
Good morning, counsel.
Morning, yeah, Trustee Stowe.
Conference and Ms. Millswright. You're on the first appearance docket today just to kind of see where things stand. I know that this case is set for trial, jury selection on Monday. Mr. McDaniel, anything on behalf of Ms. Millswright?
Your Honor, in 25340 MM, we're going to enter a plea of no contest. The charge is listed. The understanding should be sentenced to 4 months in the county jail. She have 33 days jail credit, be a $370 fine. She has signed a plea waiver, form waiver, right to jury trial, and call witnesses, and this resolved this case today.
Did you say 33 days credit, Mr. McDaniel?
Yes, Your Honor.
And Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Millswright, did you hear that agreement, ma'am?
Yes, sir.
And ma'am, do you have any questions about that agreement?
No, sir.
Ms. Millsrite, is that the plea that you would like to enter to resolve this case?
Yes, sir.
Ms. Millsrite, I'm going to accept your plea of no contest then. Disposition to the charge of violation of injunction for protection. I'm going to adjudicate you guilty of that misdemeanor offense and issue to 4 months in jail, but you have credit for 33 days. You've already served 370 court costs and fines. Case number 25-340 MM. Ms. Millsrite, as you probably know, ma'am, you very well may do less than that remaining time if you get some gain time, which is authorized under Florida law in certain situations. Hopefully you'll get some gain time and get out a little earlier. There's no probation involved in this case. Ms. Millsrite, as far as I know, that injunction is still in effect. So you've got the same rules you had before about going within so many feet of that person's residence. So unless that injunction is dropped, you've still got to follow that. Ms. Millsrite, do you have any questions, ma'am?
No, sir, I don't. Thank you.
Yes, ma'am. Wish you the best. Marquicus Calhoun.
Yes, sir.
Mr. Calhoun, good morning. Mr. Calhoun, you're here because you've been accused of 1 count of felony battery. Mr. Calhoun, there is probable cause in the complaint. Probable cause is a pretty low burden. It just means someone's accused you of committing a crime and all the elements of the crime are in and under oath sworn complaint. Mr. Calhoun, I'm going to listen to Mr. McDaniel and Mr. Mitchell before I make any kind of bond or release decision. Mr. McDaniel, anything?
No, nothing, Your Honor.
Mr. Mitchell?
I mean, the only thing I can tell you is what I was told by the arresting officer in this case was that when he took him into custody yesterday, he had concerns about there being mental health issues. I just wanted to put that on the record and let you know. So maybe that could go into effect with his bond conditions.
I wish that the officer had chosen to give us Mr. Calhoun's side of the incident. Either he wouldn't give a statement or he gave a statement. Here's what he said. The complaint makes it look like the officer never even talked to Mr. Calhoun to get his side of and there may be reasons he didn't, but it sure would be helpful to have that in the complaint, have a little more information. Mr. Calhoun, I know that you've been to prison, but when did you get out of prison the last time?
August 11th, 2017.
And when's the last time you've been charged with a crime, Mr. Calhoun?
I don't know.
It's the last 1 year. It was 3 or 4 years ago, 2023. We dealt with him, yeah.
Where do you live at, Mr. Calhoun?
I just came back from Tallahassee, sir. I mean, I was finna go back to Tallahassee for my friends to come pick me up.
So I guess my real question is, are you homeless or do you have a place to live?
No, I was talking to this federal agent, but no, ma'am. I mean, no, sir.
Okay. All right. So I can't give you a conditional release if you're homeless anyway, but I'm going to set you a lower bond than I normally would because of the complaint being so. It doesn't like there's a whole lot of investigation at all. I just there's no physical evidence to support the person's allegation. They made an allegation against you. That's all I know. I'm going to set you a $1,000 cash or surety bond with a condition of no contact with the alleged victim. Mr. Calhoun, you'll get a chance to use the phone in a few minutes and post the bond. If you can, you'll be released. If you go through a bondsman, if they charge you 10%, it would cost you $100 to get out of jail. Mr. Calhoun, the other thing is that I'm going to ask the jail to give you a notice for your court date. Your court date will be November the 4th. November the 4th at 8:30 a.m. Mr. Calhoun, you'll get to use the phone in just a few minutes. Do you have any questions?
No, sir.
All right, sir. I wish you the best.
Yes, sir.
There's nothing today to make me think there's a mental health issue. Now, there very well may be. This not today.
I got you.
James.
Yeah, there definitely is. I mean, I'm not saying that there's not. There is one, but I'm just saying he's okay. I mean, there is one with him, but it's not that severe. At least today I don't see it.
This is James Williams. Mr. Williams, good morning. Mr. Williams, you're here because you've been accused of violating the terms of your state probation. I've got a copy of the warrant in front of me. It's signed by the circuit judge, Judge Garcia, and it has no bond on it. Mr. Williams, you're going to be held with no bond until you can get to circuit court and get this allegation against you resolved. Mr. Williams, I'm going to also go ahead and appoint the public defender's office to represent you if you want. That way I can get you a lawyer appointed so we can get you arraigned. Do you want an attorney appointed to represent you, Mr. Williams?
Yes, sir.
I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, then we'll see if you have any questions.
Your Honor, we're going to ask the court to set this on the next arraignment docket, which is November 6th. Guy Green's going to be representing him, interplead not guilty, and going to take care of his case this morning.
Thank you. Mr. Mitchell, anything?
Nothing at this time, Your Honor.
And So Mr. Green will see you before your court date. Mr. Williams, do you have any questions?
No, sir.
All right, sir. Wish you the best. After Mr. Williams, we have Miss Williams, Kiana Williams, that is. Miss Williams, good morning. You're here for first appearance, ma'am. Again, for the charge of petty theft. Miss Williams, I'm going to appoint the public defender's officer to represent you. I'm going to tell you there is probable cause in the complaint, Miss Williams. Please listen to your attorney, Mr. McDaniel.
All right, spoken to Ms. Williams. She's gonna plead no contest. The charge is listed. You understand? She's gonna be sentenced to 6 months in the county jail, 1 day jail credit, $66.65 restitution, $370 in fines, and she has waived her right to a jury trial on call witnesses.
Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor.
Miss Williams, did you hear that agreement, ma'am?
Can you say it one more time? But yeah, I got it. I got it.
6 months. That's the part you gotta understand.
Okay. Yep.
Okay. Miss Williams, is that the plea that you would like to enter, ma'am?
Yes.
Okay. Miss
That's
Williams, I'm
fine.
gonna accept your question by the clerk. Restitution amount, Mr. McDaniel?
$66.65.
What is that for?
That's the food that they couldn't return back.
There was no, yeah, the complaint says, well, the complaint has two numbers in it, Mr. Mitchell. In one place, the officer put $66.65. The very next sentence, the officer put $68.88.
That's the taxes they put on top of it. They do one
Yeah, the
tax.
total after taxes.
Okay, so it'd be 66.65. So Miss Williams, is that the plea you want to enter, ma'am?
When do I have to pay this?
Mr. Mitchell, the state's agreeable with handling this as a misdemeanor if she takes this offer?
Yeah, that's what I was going to say. If she didn't accept the offer, I would probably look at transferring this to felony court.
So is this what you want to do, Miss Williams?
So, yes, am I allowed to do trustee?
Yeah, you're.
Oh, okay.
That's between you and the
Okay.
jail, unless there's something I don't know about. Just about everybody has
Okay.
trustee status, if you want to and you're willing to work. So is
Okay,
this what you want to
that's
do?
fine.
Okay. Ms. Williams, I'm going to accept your plea of no contest to the charge of petty theft. The state's agreeing to keep this in misdemeanor court, even though it appears you may qualify for felony because of the jail sentence, Ms. Williams, and the other circumstances. So it's a plea of no contest, adjudicate you guilty, sentence you to 6 months in jail, credit for 1 day that you've already served, $370 court costs and fines. You get a chance to work that off. There's restitution of $66.65, which has to be paid or be a civil judgment. Ms. Williams, there's no probation to follow, ma'am. You finish this jail sentence, you're through with this case. Ms. Williams, do you have any questions?
No, sir.
All right, ma'am. Wish you the best.
Okay, thank you.
Yes, ma'am. Mr. McDaniel, we have come on up, sir. We have a gentleman from not yesterday, the day before yesterday that missed court and he showed up this morning.
It was. Yeah, it was yesterday.
It was yesterday.
Oh, it was yesterday? I
Yes,
apologize.
sir.
So Mrs. Scott Smith, Mr. Smith was scheduled for court for the 15th, which was yesterday. It is case number 25-413 I'm taking a look at the file now to see if it was a notice or if it was a handwritten notice, what type of notice it was. Looks like a notice was sent to Mr. Smith and his bondsman. Actually, he signed a handwritten notice to
Yes,
be
sir.
here. It wasn't a mail notice. It was a handwritten notice signed by Mr. Smith to be here at 9 o'clock yesterday. So, Mr. Smith, you didn't show up yesterday like you were supposed to do. So tell me what's going on.
Well, I thought it was on the 20th and the 25th. That was my bad because it was the 15th and the 20th and I got thrown off on my days. And then by the time I got back and figured it out, it was too late. And so I just wanted to come up here and tell you there's no real excuse. I'm really embarrassed that I missed it anyway, but I'm not going anywhere and I plan on coming to court.
Well, the problem isn't you not going anywhere. The problem is if when we get ready to go to court or go to trial, you're not here. So
Yes, sir.
was his case set for trial, Mr. McDaniel?
It was, Your Honor, and I think Mr. Smith was going to resolve the case. I think he is. I'm not for sure because I couldn't get a hold of him, but it was a year probation, $722 fines, anger management class, no contact with the victim. So I don't know if he wants to resolve it today or if the court's going to take him into custody or
There's another charge out of Bay County.
What?
Now, that's probably a common name though.
Yeah.
So let's see,
Yeah, I don't
that's
know.
a Scott, that's a Scott Austin Smith,
Yeah.
and this is a Scott Allen Smith. So
Yeah, I don't get in
our
trouble no
clerk
more.
system has them linked together, but it's two different individuals with two different dates of birth, I believe. 5/10 of '03. Yeah, two totally different people. Okay. So Mr. Mitchell, is the state's offer still the same?
Yes, Your Honor, the offer still remains the same for 1 year probation.
And Mr. Smith, what was your intent at court? Was it your
You know
intent?
what? I'll sign it. I could use anger management classes. I have a drinking problem as well. I would like to talk to probation about possibly doing some classes with care or something to help me with the drinking, some outpatient stuff, you know.
So what I'm going to do is I want to ask Mr. McDaniel, it sounds like y'all reached an agreement. So Mr. McDaniel, I'm going to ask you to put the agreement on the record. And I know you just did, but I want to make sure he's clear with it. Mr. Smith, listen to your attorney. We'll see if you have any questions.
Yes,
okay?
sir. Thank you.
Mr. McDaniel.
Your Honor, I talked with Mr. Smith thoroughly at some prior hearings about this case, and at this point in time, he's going to enter a plea of no contest. Understanding he'll be sentenced to 11 months, 29 days probation, $722 fine. He'll take an anger management class while he's on probation, and he'll have no contact with the victim. And I'd need him to sign a plea waiver form, waiving his right to jury trial and call witnesses. And Mr. Scott, if you remember, I talked to you about that before. It's just basically if you plead that you're not going to have a jury trial, you're not going to call witnesses, and you're admitting that you just want to take care of this case, you plead no contest.
Yes, sir.
And Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Smith, any questions about that agreement?
No, sir. Thank you, Your Honor. I appreciate your leniency.
Yes, ma'am.
Just battery.
It's just regular simple battery. Mr. Smith, I think I just asked you this. That is what you want to do, right?
Yes, sir.
I'm going to accept your plea of no contest to the charge of misdemeanor battery and withhold adjudication of guilt, sentence you to 11 months to 29 days probation. Mr. Smith, the standard conditions of probation will apply, plus the following special conditions: no contact with alleged victim, $722 court costs and fines, which is set by state law, successfully complete anger management. You mentioned an alcohol issue, Mr. Smith. Every probation case has a condition that you not possess or consume alcohol. But if you feel like you'd benefit from counseling, what you can do is talk to Mr. Goodson or Mr. Ham, because some counseling programs, you got to go to anger management
Oh, so
anyway.
Mr. Goodson will be my probation officer?
Be Mr. Goodson or Mr. Ham.
Okay.
Mr. Ham.
Yeah, I know Mr. Goodson.
So what'll happen is that you can tell him, hey, I'd really want to go to an anger management counseling that covers alcohol too. So I could just go to one counseling.
Because that's where it starts. You know, it all starts with the first drink, you know what I mean? And then it goes down.
Well, I guess I think realizing it's probably the first step. If this is a plea you want to enter, I need you to sign that waiver of rights form, put your date of birth, Mr. Smith, and then I'll finish the sentence once you get through with that. Are y'all here for our first appearance case? What case are you here for?
I had got a letter in the mail. But I was trying to figure out, because I had to stand up Garcia.
Well, what's your name? You may be in the wrong courtroom. What's your name? Just a second, we'll pull it up. Mr. Mitchell, can you pull that up?
Yeah.
Mr. Smith, try to get everything done early because that way you can get off probation at the halfway point.
Okay, perfect.
It's the warrant on the failure to appear. It's already active, right? What's the easiest? It's probably easiest just to serve it. So when you go downstairs to get instructed, Sergeant Applewhite's going to serve that warrant down there because I don't want you getting picked up 2 or 3 months from that warrant that was issued.
Right.
So they'll get that warrant served downstairs. We got to get him a copy before he can serve it.
Right.
They'll serve it on you downstairs. You won't go to jail or anything.
Okay.
It's just got to get the warrant out of the system.
Okay, but I
Well,
don't have no
actually, if
new
you
charges come to court or nothing.
If you
for it?
serve him, you can't serve him and sign it without taking him to jail. We're going to have to rescind the warrant. That's it. We're going to rescind the warrant because I don't want you having to go to jail just to be fingerprinted
Thank
and
you so
processed
much,
out.
man. Thank you so
So
much.
if y'all get me an order setting aside the warrant, Mr. Mitchell, any objection to that?
No, no objection.
Thank y'all.
We'll
man.
set aside the
Sorry,
warrant.
won't
Okay.
happen again. You don't want to see me again.
And Mr. Smith, see Mr. Goodson. I wish you the best, sir.
Thank you, man.
Yes, sir. Did you get a chance to look that case up, Mr. Mitchell?
The only thing I see when I
Come
look
on.
up Erica
Come on up.
Cobb,
Ms. Cobb, come on up. Go ahead, Mr. Mitchell.
only thing I can see when I look her up is she just recently got put on probation by the looks of it in a fleeing and eluding case. Is that what happened?
Yeah, and I already went to court with Ms. Garcia. We done got everything resolved and everything else, but I had got a letter in the mail saying to be here at court on the 16th here. So
Is today traffic court day? Do you bring the letter with you? Was it?
I
Because
forgot
there's
it 'cause I've
traffic
been
court today. I wonder if it was for a traffic ticket.
Yeah.
There's a bunch of civil infractions. They wrote a bunch of tickets along with that. Traffic hearing 1016.
And the letter had your name on it for me to be here.
And it couldn't have my name. Well, it could have.
Cause it said, for not having seatbelt ticket and open containers in
That
the
sounds
vehicle.
like traffic. Yeah.
But when I
Okay.
stood in front of Garcia and everything else,
Give us just a second. I think we know what's going on. We're going to try to figure it out. But
Ms. Jackson is saying 25363 TR.
I see them right here. That doesn't help us. My question is, was it traffic case in front of me or in front of Mr. Larimore? Was it my date today?
Oh, that I don't know right there.
Does Mr. Larimore have a date today? Today. So it doesn't really help. And I was told there are no cases on my docket, so it must be on his.
the letter said Wade Mercer. I don't know.
Can you please? Mr. McDaniel, while Dawn is checking on that, you had sent an email this morning, which I thought was a good suggestion. Our non-English speaking docket coming up 2 weeks from Tuesday, this past Tuesday, only has one case. We have a Spanish interpreter for that, but based upon looking at the name and the background, you think it may not be a Spanish interpreter needed if one's needed at all, Mr. McDaniel?
He's Indian and he lives in an Indian community in California, because I looked up the community. It's an all Indian community. I doubt very seriously he speaks Spanish. I mean, he may speak English, but he definitely, I don't think he's going to speak Spanish. I don't even think it's going to show anyway. So I didn't know if we want to move him to the docket on Monday, the 27th.
Mr. Mitchell?
As to that defendant, I don't know if we want to move him to the 27th.
Any objection to that?
No, no objection.
That sounds like a reasonable solution, because I don't want to waste the interpreter's time. So, Mr. Goodson, if you would ask Pam to notify the interpreter, we don't need an interpreter on Tuesday, our non-English speaking day, which is the 28th. 28th. We don't need an interpreter. And Dawn, Ms. Williams, if you'd please take that one case for the 28th and renotice it for the 27th.
I just looked at the notice for Ms. Cobb. It's in front of Herman.
Okay. So
at 9:30.
one thing at a time, the 27th. Okay, thank you. Now, Ms. Cobb, let's see if we can help you resolve your case while you're here. So did you get all these tickets at the same time? The criminal charge and the civil tickets?
Yes, sir.
Okay. The criminal case was fleeing and looting?
Yes, sir.
How was it resolved?
I got 5 years probation, got Vivitrol shot.
Okay, so, and you got court costs and fines, I'm sure.
Yes, sir.
All right, so you have 4 civil infractions from the same day, it appears. Let's see what they are. So the first one, I just want to make sure there's no, something like a child not being in a safety street seat or something like that. One is you not wearing a seatbelt.
Yes, sir.
That's 360. 25-360 TR. 363 is, okay.
367 is open container,
Okay.
and 364 is a
Speeding.
35.
Speeding. Let's see what the actual speed was.
It's like 90 and 55 an hour.
It doesn't say another speed. All right, so the speeding is only one that really want to know more about. Let's see what time of day this was and where it was. 5:56 a.m. River Road. Welcome Church. Yeah, 90 miles an hour right there is flying. That's fast right there. That's fast anywhere except the interstate. Okay, so let's take a look at your driving record. I don't know that I have it because it's not my case. I don't know if they pull driving records for traffic court. It's a hard copy
Yeah, Garcia, yeah, I lost my license for like 5 years.
from this incident.
Mhm.
How much fines and court costs were you ordered to pay in the felony case? It's okay.
11.
All right, so if you want to plead no contest to these 4 civil infractions, if you wish to, I'm I'm gonna waive the court costs and fines because you've already got $1,100 court costs and fines and something else from the same day and same time.
Yes, sir.
Okay, I'm also going to withhold the points off your license because you've already got a 5-year suspension.
Yes,
So you've been punished for that day and that incident.
Yes,
You
sir.
don't have to plead no contest. You can hang around and go to a traffic court hearing in front of the hearing officer a little while, but if you want to resolve it without going to the hearing, you can do that because you've already been punished.
Yes, sir.
Would you like to plead no contest if I waive the points and fines on these 4?
Yes, sir.
Shall plead no contest to those 4 infractions, waive the points, waive the fine. So these are over and you've got much more serious things to deal with in felony court.
Yes, sir.
Okay, well, it's over now, but you've got probation. Make sure you follow your probation.
Yes, sir. My probation officer, she tried to pull it up on the, on her behalf, but it didn't show nothing, but she still told me to just show up.
Yeah, and that was the right thing to do. So we'll go ahead and get it taken care of. Just wait a second, we'll get that signed. Mr. McDaniel, thank you for waiting. I know that we wanted to talk about that issue which you brought up with the Spanish docket, which we covered. Oh, was that the last trial case?
Yes.
Correct, yes.
So, Ms. Williams, if you would notify Ms. Green that we don't have any trials, please. Mr. McDaniel, anything else from the Public Defender's Office?
2 things, one off the record, I guess. Make sure someone lets the trooper know that that case has been resolved, so you don't sit there all morning. And then something off the record.
Trooper Maloney, he may have, thank you, Mr. McDaniel, for that. We'll make sure of that. All right, so Mr. Mitchell, anything else on the record?
No, Your Honor.
And Corporal, anything else, or is that Corporal or Sergeant? That's the Sergeant in there now.
Sergeant.
Did we have the Corporal earlier?
Yeah, he was here.
He's always here.
They already left me in here.
Y'all just switched on me. You got me confused. I got the beginning stages of Alzheimer's, I think, sometimes anyway, and had me confused there for a second. But thank you, Sergeant. I guess, ladies and gentlemen, that concludes everything.
And he's done. Let's go, let's stay in Florida, but we'll head further south, Miami-Dade, to see how Glazer's doing.
In terms of criminal history, the defendant's got a prior federal conviction, 116 months, followed by 36 months of supervised release. And that looks like it involves fraud and stolen mail.
So there's probable cause, I believe, for everything. Let's see on page 6 he's on. So count 1, trafficking in ecstasy. Looking at his priors. Okay, $15,000 bond. It's a first-degree felony. Count 2, trafficking in oxycodone. Sorry, I see promethazine hydrochloride.
It's 9 grams of oxycodone. To traffic, you need 7.
I didn't see it. I'm sorry.
It's 9 grams. To traffic, you need 7. It's on page 3.
That's correct. There you go. In the trunk. You got more stuff in the trunk. Xanax. He was also in searching and he had the oxycodone 9 grams in his underwear. Okay. 9 grams. You need how many? 7?
Yes.
There's probable cause. For that.
Judge, 7.
Excuse me? Mr. Del Valle, did you say something?
No, I said that's correct, Judge. You need 7 for the trafficking. That's the limit.
I'll set the bonds on count 2 at $10,000. Count 3, possession with intent to sell cannabis.
Count 3 is the MD.
Oh, it is? Sorry, count 3 is trafficking in ecstasy. Well, didn't we get that one already? Because he had 2 sets of ecstasy. You want to ROR? I guess ROR that one.
Thank you, Judge.
Split 1 and 3. You want me to split 1 and 3?
Whichever way, Judge.
All right, count 1 will then be $10,000. 2 is $10,000. 3 is $5,000. Count 4, possession with intent to sell cannabis. You're not talking about a lot of cannabis. You want $1? You want an ROR? What do you want?
$1.
An ROR if you can't, Judge.
He wants an ROR. That's fine. There's probable cause. Count 5. So count 5 is the mushrooms. There's a little bit of mushrooms. I'll do an ROR. Count 6 is count 6 is Xanax. It should be possession of Xanax. He had like a small amount. One Xanax bar. That will be, count 6 will be $1,000. Count 7 is an MDMA. That's $2,500. Count 9, possession of a prescription drug without a prescription. That's, I guess, the promethazine hydrochloride, I don't know. $150. Did I get it all? Yep, that's it. You want me to repeat it? The 10,000, 10,000, 1 and 2 are 10,000 each. 3 is 5,000, 4 ROR, 5 ROR, 6 1,000, 7 2,500, $850. Okay, there's
Thank you,
no
Judge.
idea he can bond out. You have a good lawyer. Listen to what he tells you. Thank you so much.
Have a good day, Judge.
You too. Do we have Lenny Reynoso?
Not yet.
Okay, when he's here, let me know. Page 1. Eva Mascaro. Whoever's here for Falcone again, we told you, go to courtroom 5-3 for traffic tickets or call the attorneys, not before this court. Okay. Good morning, Miss Mascaro. You were arrested for aggravated battery on a law enforcement officer, and battery. I will appoint the public defender's office for you. So there's probable cause for, what's the aggravated battery? I'm sorry.
Should be assault,
Yeah, you're right. It should be an aggravated assault.
not ag.
I agree.
Okay. Or resisting.
It says that she drove the vehicle towards the victim.
You are ordered to stay away from the alleged victim, Jonathan Escribano. And if there's any victims here on Zoom, when I'm on your case, please raise your hand so I can promote you. You are ordered to stay away from Jonathan Escribano. No contact with him either directly, indirectly, in person, in writing, by telephone, through third parties. No contact with the victim through social media or other electronic means. And you must sit at least 500 feet away from the victim, his home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and follow receipt with the court. And you may return to the victim's residence.
They don't
What?
live together, Judge.
Do you have to go there to get your stuff?
Yeah.
You may return, that's what it said, it didn't say it. You may return to the victim's residence one time only within 48 hours of your release from jail. You must be accompanied by a police officer so that you can retrieve your personal clothing, health items, medication, personal and business-related paperwork and work tools. If you go to the victim's home without the police or if you stay there, you will be arrested. Do you understand the stay away order?
Yes.
All right, thank you. So I gotta set a bond.
Judge, would you consider any program for Ms. Mascaro? She does not have funds for a bond.
Does she have any priors?
I mean, she said, I'm gonna F you up and made threats to
He
kill
was drunk.
deputies. Prior domestic violence arrests, not convictions. They're recent.
Yes, recent ones, they were no plus. All right, count 1 is probable cause for, you said you want aggravated assault with a deadly weapon?
Yes.
Want house arrest?
That or pretrial. I prefer pretrial, but.
Judge, I don't think pretrial is appropriate when she threatens to fuck up and kill deputies.
She was drunk.
That's not an excuse.
I agree. Second. All right, so count one, I'll give her house arrest with a GPS monitor. Alternate bond, count one. The aggravated assault with a deadly weapon, I'll set it at $2,500. Count two, battery on a law enforcement officer. It's $2,500, and count three, battery is $1,000. I'll do level 3 house arrest. Maybe just give her a curfew. Happened at 8 o'clock.
She works for DoorDash, Judge.
All right, I won't do a curfew.
Okay, thank you.
Just stay away from the victim. Have a good day. Next, Katie Fisher.
NBC, Your Honor.
NBC. Let me review probable cause. Why did that last day? We ordered back. Yeah, where's the rest of it? I need to fix it.
So
Sorry.
no intent on the cocaine.
You know, I don't know. Are we on the regular thing? I cannot barely hear you.
So no intent on the cocaine. She's out on bond. I don't know if you want to waive her presence.
A waiver.
So video, I can't really hear the state every time she speaks, and I'm getting fed up. So I think I'm going to stop court until it's fixed. Or we go on a platform where I can hear her.
Because I can hear Miss F pretty well.
That's good, but I can't, and I didn't know what she's saying, just like I need to know what you're saying.
I agree. But just IT news. So, Judge, we'll waive Miss Fisher's presence.
I'm sorry?
We will waive Miss Fisher's presence.
Oh, okay. You said just possession of cocaine? Is that what
Yes,
you
there's
said?
no intent. It's one baggie.
So count one is possession of cocaine. Count two. Wait a minute. There's probable cause for count two then as well. So appoint the public defender's office. Waive defendant's presence, and I'll set a bond. Count one is $2,500. Count two is $2,500.
With the hold, Your Honor?
With a hold for F 258715. No, she's. And now we have Heather Harvey, page 1. Good morning, ma'am. You were arrested for battery by a detainee on another detainee. I will appoint the public defender's office for you. There's probable cause. $2,500 bond. Have a nice day. Please don't fight at the jail.
So I'll keep an eye on it. She's definitely getting cranky, but honestly, that IT staff there, whoever it is who redid the audio when they did the quote unquote upgrade in her court, they probably shouldn't be employed. And I don't generally make those kind of statements about people, but it is just, it's bad. They need to fix it. Oh well. Let's change it up. Let's go to Kentucky. Judge David Williams. Let's see what he's got going on this morning. Oh, hold on. There we go.
Thank you. Everybody have a seat. We have some prisoners transported today from Department of Corrections prisoners. Is that correct?
Miller, William Miller.
Are you William Miller?
Yes, I am.
Good morning.
Good morning. How are you?
I'm blessed. I hope you are too. This is 25 CR 0025. Mr. Miller, were you born in 1980?
Yes.
Last four digits of your social security number 2359.
Yes.
We're here for a pre-trial conference. What does the Commonwealth have to say?
I believe we have a felony plea. Is that correct?
That is correct.
Mr. Miller, a motion, I've just been informed of a motion that says you wish to enter a guilty plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given? Are you the same person that we just identified in 25 CR 0025?
Yes.
Is your judgment impaired today in any
No.
way? Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you, believe you're fully informed about your case? Do you understand that you do not have to enter a guilty plea today? You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know you understand those rights. I'm going to go through the rights and then I'm going to ask if you understand. If anytime you have any questions, you can step away and talk to your attorney, okay?
Okay.
You have a right not to testify against yourself. No one can make you say anything. Your right to speedy trial, but jury, your right to be represented by counsel to jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter to higher court. If you lose, you have a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering guilty plea today, you give up those.
Yes.
Okay, now I may consider the Commonwealth's recommendation that I'm about to hear, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting any recommendation, I will have a pre-sentence investigation report done by probation and parole. In the event after reviewing the Commonwealth's recommendation in that report, I decide to impose a harsher sentence, you have the right to withdraw your plea and go to trial. You understand that?
Yes.
You step to the left slightly, and Mr. Judd, are you going to come forward? And Mr. Miller, listen carefully to what he has to say here, okay? Go ahead, Mr. Judd.
The Commonwealth agrees to dismiss giving police officer false identifying information, KRS 523-100 Class B misdemeanor, and also failure to signal, which is a violation, and operating a motor vehicle while license is revoked or suspended for driving under the influence, Class B misdemeanor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 1 year to serve. This 1 year sentence shall run consecutively to Monroe Circuit Court indictment number 22 CR 00104. The Commonwealth opposes probation and shock probation. The defendant agrees to have any and all evidence in the above style case forfeited and destroyed in a manner that is consistent with the laws of the Commonwealth of Kentucky.
Sir, is that your understanding of Commonwealth's recommendation?
Yes.
Are you pleading guilty because you did commit the acts charged in the amendment, in the indictment as amended?
Yes.
You doing so of your own free will?
Yes.
Okay, knowing your constitutional rights, still your desire to proceed and allow the court to fix your punishment according to law.
Yes.
You understand, by entering this plea, any future convictions will be enhanced under persistent felony offender law. Is that your signature on the plea agreement?
Yes.
Okay, I'll accept the plea agreement and we will schedule sentencing for November the 13th, which is hard for me to believe it's November already. You know?
Your Honor, if I may, he is a state inmate, and we are willing to waive the PSI this time and ask for him to.
Okay, he has been continuously confined since the last sentencing, so we'll waive it, we'll enter the sentence today, so you won't have that. But I mean, if you want to come down.
No, I don't like driving 3.5 hours like this. You
Yeah,
know?
I understand. Well, you get to see the neighborhood, you know.
Yeah, I mean, it's good to see home, but still, yeah, but.
Well, I hope I hope you will. Yeah, I hope you can turn things around, man.
I'm going to.
Okay.
I got 3 youngins out here that says I got to.
Okay, well, they're sticking with you. And a lot of people don't have anybody, you know.
Thank you, Your Honor.
Yeah, here's that envelope there. Go with it. Thank you. Now, who's the next person we have for corrections has here?
Waiting court calls.
Pardon?
Waiting court calls.
Yeah, I'm gonna waive, consider the length of since I'm waiving court costs. Okay, who do we have now from, that's been transported by the Department of Corrections? Yeah. Give me a name here.
I would think.
Robert Tabor, Your Honor.
Robert Tabor. Good morning. Are you Robert Tabor?
Sound?
Mr. Tabor, were you born in 1987?
Yes.
Last four digits, social.
Yes, sir.
We're here on 25 CR 0043. A motion for release of records, is that right?
That's correct, Your Honor. We had.
I'm not objecting, Your Honor.
Okay, well, when we have something like that, it'd be good if we do an agreed order on that, because this gentleman's had to drive down here. I mean, what's the deal?
Your Honor, we were needing Mr. Tabor transported down here regardless. We have not been able to make contact with him to go over.
Well, we don't run a taxi service. Part of your representation is for you to meet him up there. So we'll sign the order and we'll do it. Mr. Tabor, I hope you have a good trip back up there. And sorry to inconvenience y'all.
Your Honor, if I could, I've spoken with the individuals from the transport staff. There is a form that they have for the court, if the court is willing to sign, that would keep him in Barron County while.
I'm not going to get involved in that. I'm not going to get involved in that. This is the Department of Corrections decision. I'm not going to start ordering them to move people here, there, and yonder. You know, they got enough problems already. I'm just not going to do that.
I understand, Your Honor. This would.
I'm not going to do that. Thank you.
Thank you, Your Honor.
Yeah. Okay, who else do we have? What's your name, sir? Marlon Stout. Well, good morning, Mr. Stout. This is 23 CR 007. Mr. Stout, were you born in 1995?
Yes, sir.
Last four digits. You're here on a probation revocation. What does the Commonwealth have to say?
Your Honor, Mr. Stout has a 10-year sentence on theft of unlawful taking. He was revoked in Barron County. Is he going to stipulate?
He is, yes.
Okay, stipulate, we'll just, and then it's gonna run concurrent with that Barron County time?
It is, yes.
Okay. Okay, we'll sign the order.
Judge, on Mr. Tabor that we had here earlier, we didn't set any future court dates.
Well,
He was just for the motion for release of records and on for free trial today.
There's no future pretrial on that.
Right, that's what I'm saying. We didn't say anything in the future.
I don't mind if we want to say the 7th and the 21st or 7th and the motion date. Hang on a second.
that was a previous witness.
It was Mr. Tabor.
Oh, Mr. Tabor, will, what's the negotiation date?
November 7th, 9.
November 7th. And the next court date is November 13th. So we need to put that on the order.
That's why I was
Okay.
asking.
Okay, that'll be on.
Just hang on a second.
They don't have all that. See if they have the paperwork on both of those people back
They
there.
don't know Mr. Tabor. I'm doing it.
We're doing Mr. Tabor's paperwork now.
What that gentleman showed me, the body receipt as if they were. Have no paperwork over the flyers.
Yeah. All right. If they plan on, well, they did if I signed it. Was that the
Said he
one?
didn't need it signed.
You what?
Robert Tabor, he said he didn't need it signed. The officer did, so.
I've got his document here.
This is actually Stout. You can-
The Stout. Wait.
Okay, yeah.
So it always happens when we take people out of order. It starts confusion, you know.
I'm sorry.
I know, you know what I mean? No good deed goes unpunished. does it?
Absolutely.
Okay, Brian Cook. Brian Cook. No. You think they're planning on leaving one? Brian Cook.
I'll get there first. I will go to public.
Commonwealth versus Brian Cook, 20 CR 0053. Are you Brian Cook?
Yes, sir.
Good morning. Were you born in 1972?
74.
They got you on here wrong. You just gained 2 years right there.
Yeah.
Yeah. And this is, his last 4 digits, social security number 71. This is a shock probation revocation. You moved your left a little bit, sir.
Your Honor, Mr. Cook has a 3-year sentence on possession of a controlled substance, first degree on October the 5th. He was stopped for DUI in Barron County. He was stopped by the officer. We have the video cam. He blew a .270. We're asking that he be revoked. I've had the officer here to testify. This,
Okay. Y'all want to stipulate?
Your Honor, we are stipulating to the factual allegations. He
Okay.
did pick up that charge.
You want to be heard then?
Yes, Your Honor. Mr. Cook does want to testify as to some mitigating information for the court leading up to the DUI charge.
Okay. So you don't need to present any proof, but we'd like the officers to stay around just in case. Okay. Just for a second, then we'll release off. Yeah, your right hand, please. Swear the testimony you're about to give us the truth, the whole truth, and nothing but the truth.
Yes, sir.
You may proceed.
Mr. Cook, you are not currently in any way contradicting the allegations that have been made against you, correct?
No.
So, Mr. Cook, can you explain to the court what was happening in your life immediately leading up to picking up this DUI charge?
My mother's husband, they've been married for 25 years. He got deported to Honduras and he sold the house up in Honduras. In 30 days, I had to figure out how to take care of her. Well, was taking care of her and I just I had to slip up. Went out, had a few drinks, got stopped.
And you acknowledge that this was not the correct course of action to have taken?
No.
Mr. Cook, if the court was to give you another opportunity to be released onto your supervision, are you willing to comply with any conditions that he has placed on you?
Yeah.
And rather than taking this course of action whenever things go wrong in your life, are you willing to talk to your probation officer about maybe support resources?
Yes.
Okay, I have no further questions.
You don't have any questions? do you?
I don't have.
Okay. Well, one of the great fears that any judge has is to have somebody on probation, shock probation, or pretrial release or bond that gets out and has a slip. You didn't just have a few drinks, you had a lot of drinks, to testify that. And you get over and run over a school bus. And the first thing they say, well, why in the world did that judge let that guy go? So, you knew what the conditions were, and I don't want to be mean to you. Okay. I just can't overlook that. And so I hope you can turn things around. Okay. Thank you very much. Motion for shock probation denied. Okay. Who, I guess we got Justin Gillespie. Commonwealth versus Justin Gillespie, 25 CR 0049. Are you Justin Gillespie?
Yes, sir.
Good morning. We're here on 25 CR 0049. Were you born in 1985?
Yes, sir.
Last 4 digits. 7.
Yes, sir.
We're here for sentencing.
Judge, I would ask the court to put out sentencing for 1 month because Mr. Gillespie's had trouble in the special court. He wouldn't test, and he absconded, and he got caught. And I don't know if we're playing yo-yo back and forth with drug court, but they didn't terminate him this morning. So I don't know if they're planning on taking him back or what, but if they don't, I don't know what to do in this case, to be honest, because he's not done what he's supposed to as part of our agreement.
I was trying to get him to.
Hold on,
Sorry.
don't say it. Judge, I also would ask if we could continue this, so that I can speak further with Mr. Gillespie and Mr. Stockton about what options that we.
What were the violations he was accused of?
He was, 1, he didn't test in drug court, and 2, he absconded. He got picked up on the warrants, my understanding, is that right?
How long was he gone?
No. Now I don't have the paperwork from drug court, so I don't know. I'm counting the law or something.
Whose dime is he on now?
He will be on the county down until he's sentenced. So
Yeah,
all that in consideration.
Yeah, I'm not real big on somebody being in drug court, not complying, and then charge Monroe County.
The sentence that he's to be received today is your, that's complicated. You sentencing a single back.
If he's sentenced today, he goes back to drug court.
Well, if he's sentenced today and he's probated, you can do whatever conditions you want, or you can sentence him and not probated, or you can delay sentence. And Scott thinks about the 3 options, the only 3 options.
It's 3 years since probated for 5 in drug court is the sentence.
Yeah, that's.
And he violated it. And
So
so instead of seeking a violation on the probation, you're seeking you're dealing with whether drug court's gonna violate him, which I don't know why we couldn't address, he violated his probation.
That's correct.
Is he on probation?
He's not
He's
on
not
yet,
on.
and I guess this is the issue.
Well, how is he in drug court on pretrial?
Well, I don't know how, I guess they went ahead and got him in or didn't him before the sentence. I guess is what happened.
And Your Honor, if I may, I believe he had only been out for just a couple of weeks leading up to that.
Just a couple of weeks.
Just a couple of weeks.
Yeah, that's because they caught him.
Judge, if I may.
Yeah.
Part of drug court, if they have problems, we look at the fact of sending them to rehab, a long-term
But
rehab.
what was he doing? How did he get in drug court? Did he enter a plea here?
The interplay, he's on for sentencing today.
Okay.
And they must have.
So they went ahead and got him into drug court early. Is that what? You're on drug court board, aren't you?
Correct.
They got him in drug court early.
But all of this.
And he violates before he can get sentenced.
Correct.
Yeah, this is one we did information indictment.
Oh, rocket docket, I see.
That's probably the reason.
Yeah, I understand it now. I'm gonna revoke your probation and we'll skip. I'm gonna sentence you today. But I'm not gonna probate you.
Your Honor, if you are rejecting the agreement that we have reached with the Commonwealth, we would request to withdraw that agreement.
Okay, well, we'll schedule him for trial, right?
Yes, sir.
Okay.
There it is, yeah.
I was gonna shock probate him, but that's okay. Let's get calendar out. I'll tell you what we got.
It's a possession case of immediate they'll have.
About March 4th.
You said March the 4th.
He did.
That date is fine with me.
Do we need a negotiation day? No.
That's me. That one's across the lab, is that?
Looks like we have no.
All right.
Okay.
Okay, let's take care of it. What's the number on it?
25 CR.
Okay, we're going to switch things up here in a minute, but before we do that, let's take a moment and talk about the sponsor for today's live program, and that is our friends at Aura. So I was just doing a little bit of reading while Judge was doing his thing there about data brokers. Now, this is where Aura comes into play, and we watch enough court to realize there's a lot of bad actors out there in the world doing a lot of bad things to good people. But what happens when you have companies assisting these bad people in doing bad things? And that's kind of, unfortunately, what a lot of data brokers do. But I pulled up a search for data broker fraud cases. And just filed by the FTC, just them, no other government agencies, a case for Mobile Walla, who is a data broker. They were accused of collecting and selling precise location data, including information that could reveal visits to sensitive locations like medical clinics or places of worship. Gravy Analytics was charged with selling products that targeted consumers based on sensitive characteristics and behavior. Xmode Social, another data broker, had allegations that they resolved that they were collecting and selling consumers' precise location data without sufficient consent. Dun and Bradstreet had a $5 million settlement over allegations that it violated a 2022 order to stop collecting certain data, but they went ahead and did it anyways. So there's a lot of bad actors out there that are gathering your data and doing very, very bad, not good things with it, but that's where Aura comes into play. If you look on your screen here, this is all the things they can do for you. Identity protection, transaction monitoring, spam and junk removal, antivirus, a VPN, parental controls, a lot of things they do. It's a one-stop shop, but the biggest thing they do is they get with these data brokers and they say, hey, stop it. They go to all of the different data brokers, they look for your information. If it's there, they give them an order to tell them to stop. And they'll keep giving them the order because they keep checking back. If they bring back your data, they'll tell them to stop again. And it's one big game of whack-a-mole that they play on your behalf. Unfortunately, we're in a place where this has to happen. You have to protect yourself online, and it's too big of a job to do it yourself. But the good news is with Aura, and with their agreement with this channel, you get 14 days for free to try it out. Go to aura.com/TCF. You can type that in. There's a link in this video's description. You can scan the QR code, whatever your pleasure. But there's no reason not to give it a try. I made them prove to me what they could do before I ever took them on as a sponsor. Within 24 hours, they showed me where all of my data was, and within 48 hours, they'd already removed a lot of it. So you'll definitely find out in 2 weeks what they can do, and then you can decide whether or not you want to continue with them or not. But I will tell you that they're worth it. I don't leave myself vulnerable online. You shouldn't either. Again, we watch enough court to see the bad things that people do. So aura.com/TCF. Go give them a try today. It's definitely worthwhile. All right, let's go to Louisiana. Let's see what's going on with the board this morning.
Okay, good morning. The Committee on Parole is called to order. The date is October 16th, 2025. The time is 9:40. My name is Carolyn Stapleton. I will serve as the chairman on today's panel. My colleagues are joining us by Zoom, Mr. Danny Byright and Ms. Jerry Ledoux. My remote is at DOC headquarters in Baton Rouge. Today's remote location is Raymond LaBorde Correctional. Staff, will you introduce yourself for the record, please?
Brent Thompson, Warden.
Morning, Tom.
Warden.
Nikki Shinver, Deputy Warden. Raven Heath, classification.
Joseph Board on Records.
Okay. All right, thank you very much. All right, so Mr. Holmes, today, would you introduce yourself for the record with your DOC number, please?
Horace Holmes, 404271.
Okay, I'm going to read some information into the record. And you will at the end tell me if it's correct, okay? I'm Taurus Joanne Holmes, DOC 404271. Your first class offender, your offense is manslaughter and armed robbery. Your sentencing date was October 13th, 1998. You were sentenced to 40 years at hard labor and then concurrent with 55 years at hard labor. Your parole date is January 30th, 2023. Your good time date is January 22nd, 2045. And your full term date is December 18th, 2052. Is that all correct, sir?
Yes, ma'am.
Okay. Will you tell us, in your words, why are you incarcerated and why should we release you early?
Yes, ma'am. First and foremost, I would like to just apologize to the Martin family for the hurt and pain that my actions have caused them for so many years. I'd also like to apologize to my family because of these same actions. I have placed burden, shame, and hurt upon them as well. 28 years ago, I was a 19-year-old young man, selfish, uncompassionate. I chose to make the decision to go along with the robbery that resulted in the death of Mr. Kevin Martin. There's nothing I could do to correct that. It's nothing. The hurt and pain that I would cause that family, it can't be, I can't put it in words. It's not a word that I can put it in. I strive to do better because I know the damage that I've caused. So many people have been hurt from my actions, not only the Martin family, but the ripple effect of communities. I understand that, and that weighs heavy on me today. I push myself to go hard. I push myself to better myself. I've struggled throughout this incarceration. Times and times again, I pick myself up because I want to change for myself. Today, as a man, I stand with integrity. I strive to help people. I'm an NCCR core instructor. I help teach man's skill sets to give them a sense of substance to go back into society with. I'm an AA facilitator. I participate in tutoring, giving time to people that's trying to get their GED. Some people feel like they have learning disabilities. I was in special ed. I was a slow learner, but I still was able to achieve my GED. It's about finding ways to articulate to help these young men find out a way to learn. So every day of my life today, I push to do better for myself and for everyone around me. Participating, leading by example. These things is just not things of a daily routine. This is what I became today. You know, man, I look at so many young individuals, pay attention to the news, you know, epidemic with fentanyl. I look at these crimes, you know, younger and younger and younger. It makes me reflect back to myself, you know, decision-making skills. Most people, even myself, made decisions, horrible decisions from wanting to be accepted, being afraid to step out on their own as a man. That was the decision that I made. So I used my mistakes, my past, to try to mentor a lot of the younger brothers here. I encouraged them to get in self-help programs, to take on a positive mindset. I challenged them, you know what I'm saying, to push their self. Don't indulge in the negativity of the prison system. I walked those walks. I beat myself down. To become the man I am today, I had to face myself. Made a searching and fearless moral inventory is the fourth step in AANA. That's a step that I had to make. I had to face myself. I didn't understand the hurts and hang-ups that I was dealing with from a youth into an adult. And it took a lot of years into me being an adult to really just break. It's so much in rehabilitation to where if you're not applying yourself, there's no such thing as rehabilitation. To actively take self-help programs is the step that I chose to do, the decision that I made to actively take these programs. Doing so, they're giving me the tools to rehabilitate myself. I use these tools every day of my life to be of some type of service for my community here. Not only the inmates, to the staff. I go out my way. Anytime I'm needed, I'm there. I got 4 young nieces and nephews at home. I speak with them 2-3 times out of the week. We do study work sessions on the phone, Bible studies, you know, everything I can to help them beat the statistics and odds of becoming a statistic of a young female that's being impregnated, 13 years old, 14 years old. Anything in my power, I push to not allow them to be a statistic of going through reform schools. When my mind state is when you allow yourself to start going through reform schools and things of that nature, you done already accepted a mind frame of adapting and accepting the unknown. So most of us, even myself, I come from a broken home. So I feel like I understand a lot of offenders, a lot of these youth offenders. They got so much balled up in them to where they don't understand. They angry, no father, parents on drugs, things of that nature. So with that being given a chance to be of purpose.
Yes, sir.
Given opportunity to
Yes.
go back into society, I could be an asset. I have a strong support cast and just, my plan, credentials to CCCR, NCCR to go into the field of construction. My family, parole board, they helped me make the transition to go back into society. I'm willing to work with the parole board and parole officers to be implemented in programs.
Okay. Well, thank you. You spoke very eloquent for yourself. Thank you very much. Staff, are there any comments that you'd like to make?
Yes, ma'am. Currently Holmes is doing pretty good. Just starting out with his dictionary. He hadn't had a write-up since 2018. The write-up he did have then was of a country band but it was only of a cigarette. So he's done pretty good as far as the dictionary is concerned. He is applying himself, as he actually stated here. He's a voc tech instructor. He's also facilitated with AA and NA, but he's doing pretty good.
Okay, thank you very much, Warden. Okay, we have with us supporters. I'm gonna read out the names and then call out who's gonna speak. Mr. Kerry Myers is here with the Louisiana Parole Project. Quintella Cias is on Zoom. She's not gonna speak, and that's a cousin, but in support. Clintonia Williamson is gonna speak on Zoom, and that's a cousin. Calvin Henderson is a friend. He's in support. He's not going to speak. And then Jacqueline White is your mother, and she's going to want to speak. So can we start with your mother first, please? And please limit your comments to about 3 minutes each, please.
Good morning. My name is Jacqueline White. I'm Charles Holmes' mother.
Yes, ma'am.
At the young age of raising 3 sons as a single parent, I had my mishaps. So with my mishaps of going down the wrong lane, the boys went down the wrong lane. My family stepped in to help take care of my boys to get back on their feet. With that being said, I done had my journey as well through incarceration, but it brought me back to being a mother that knew better then and know better now. But it was a tad too late, if I should say, because everybody was wilding out, being rebelling, and it led to other things. I had a 7-year sentence. And so with that, I did 4 years at down here in Marksville. I don't put it so far in my mind, I can't think right now of what the prison was. But with that being said, my son Charles, he realized years ago of the mistakes he met of being a follower and not a leader, what was instilled in us as children coming up. When you see wrong, run from it. Well, by being boys, they did what they did, and all that was in the situation, they all was raised the same way with the same morals, but did what they choose to do. And that's drug selling, drug taking. So at the end of the day, this what happened. So as he done growed up to be a young man, I have seen 190-degree turn in my child. We speak often every weekend, and he's ready for society, learning things, not just what he had to do, but for himself to be better.
Yes, ma'am.
And that's probably just what it is, I know he done changed to do better for himself and to come out to take care of his nieces and nephews so they don't go down that same path. That's a blessing. And with the Martin family, I'm a mother myself. I'm truly remorseful for them as well, you know. It's devastating.
Well, thank you for your words about your son and also your sincere regrets for the family. Appreciate. Yes, ma'am. Okay, so now we have Miss Williamson on Zoom. Would you like to speak, please? It's on mute.
You able to hear me now?
Yes, ma'am.
Thank you. Good morning to the parole board and the Martin family. I am Clintonia Williamson. Taurus Holmes is my cousin, and I'm attending this parole hearing to show my support for him, not to dismiss or minimize the seriousness of his actions or the pain caused to the Martin family. Taurus and I grew up together, and as he stated, we both struggled with life as teenagers. Those years were full of confusion, broken homes, drugs, and fathers not being around, just to name a few. It often felt like we were fighting battles that would never end. Taurus has been serving his sentence since 1998, almost 3 decades. Speaking with him when he calls his mom, I feel in his heart that he is very remorseful. While there are no excuses for my cousin's actions, I know that, as I said, he regrets his past decisions. Taurus has taken time to make changes to his life to assist him on his journey to being a more productive person. He has earned his GED. He has completed self-help programs, as he has stated. One thing that truly caught my attention was the victim impact. That meant a lot to me. Not only has Taurus completed those self-help programs, he has taken numerous management courses. And I want to elaborate because he did a great job explaining it himself. He has done many things to become more productive and responsible to help himself overcome things. Yes, I am aware that it will take lots of support, and he will get that. He will truly get that. But with that being said, our family stands ready to provide Taurus with the support that he needs. I believe that having that support is essential for him to continue the growth. My aunt, his mother, has relocated from Alexandria, Louisiana. To me, this was a very smart decision. It will allow him to be closer to the larger support system. Taurus today is not the same person that he was in 1998. He has matured, gained wisdom, and used his time in prison to reflect and grow. He truly understands the impact of his decision on the Martin family. In conclusion, I truly understand that parole is a privilege and not a right. I understand that, but I sincerely believe in my heart that Taurus has demonstrated genuine change and is ready to continue on a positive path. And I respectfully ask that you give him the opportunity to prove this. And again, I will say, I respectfully ask that you give him the opportunity to prove this. Thank you for your time.
Well, thank you for speaking in behalf of your cousin. So let's see, we'll go now to Mr. Kerry Myers with the Parole Project.
Good morning, Kerry Myers with Louisiana Parole Project. We're here to let the board know we have accepted Taurus as our client, and for several reasons. One is the fact, as he stated, and his support system, his family has stated, he's done significant work, but in particular, since his denial in 2023, in the last 2.5 years, he's done significant programming. 2 things can happen on a denial, as the board knows. Someone can spiral and go down, or they can take it as an incentive to continue to work. And he has continued to work He has completed significant programming both with AANA and NCCER, also financial literacy and other programs that he has taken. He's earned his GED during his incarceration. He's taken Thinking for a Change in Victim Impact, Trauma Healing. The programming itself shows that he is committed to the work of self-improvement. His remorse is genuine. As a 19-year-old when this crime happened, while we know what the Miller-Montgomery standard says about juveniles, we also know that the brain science used in Miller-Montgomery says you're not fully developed until you're about 25 or 26 years old. He had 2 co-defendants, and that's not an excuse, but it is an understanding of how influences, outside influences can lead people to actions that are not only harmful but regrettable. We believe that Taurus is an excellent candidate for reentry in our program. We will provide him the services, the transitional services that he needs after 28 years. That includes things like technology, financial literacy. We'll make sure he has a bank account. We'll connect him to his services. He'll have a mentor, a personal coach while he's with our program. He'll have case management at minimum of 1 year. We'll continue to work with Taurus. We just believe that he's done the work necessary, that he's ready. He's at the current age. He's at a sweet spot for employment. He does have the skills, and he does have the support system. So we'd ask this board to consider granting his parole today under whatever conditions they would deem necessary.
Thank you very much, Mr. Myers. Okay, at this point, we're going to go to the opposition, and we have Joseph Martin, the victim's brother, and then we have, who will speak after him is Mr. Derek Johnson, the ADA from Rapid. So right now, Mr. Martin, would you like to speak, please?
Yes, good morning. I'm Joseph Martin, Kev's brother. Speaking on behalf of my family, we all still like dealing with stuff,
Yes.
counseling and everything else. So I hear Taurus, but he's here. My brother's not. I hear all these things that he can do. I can hear all the everything else, right? My brother didn't have that chance. He don't have that chance. His life was taken execution style. That's something that I know. I've been to counselor a lot. I have like a folder that I go through that I look at and try to figure out everything, and it still hurts. I know my mom, her life completely changed. She couldn't go back to her church around her friends. She doesn't sleep in the bedroom that's close to the house. The house was across the street that Kev was murdered in. She doesn't get out the house that much, right? It's just it's a lot. I know that you talk about age and stuff, but you know that was a decision, man, and that was a life decision. Um, it was something that we say mistake, mistakes you could correct, mistakes you can people still hear. Um, the last picture I have of my brother is still like his graduation outfit from high school. My mom, she still has it, a big picture on our wall in the house every time I go back home and see that. Um, yeah, it's a lot. Um, I don't think that anybody deserves to walk the street after taking somebody else's life. Um, that's not a right. That's not a right. And then for my family to know that two others are out, and then when I go back to Alexandria, I'm living in Richmond, Virginia now. And when I go back to Alexandria, I still have cousins and everybody else like, hey, this person is in town, or this person just came through town, or and then I'm worried about my family, my mom, and everybody else on these dudes here that killed my brother, right? So I know it's on their mind. And it's just man, I ain't gonna say hate, but I ain't got nothing for you, bruh. Nothing. It's just you are what you deserve. You deserve where you are right now. You deserve worse, but you at the minimum where you are right now, that's where you need to stay.
Mr. Martin, I can see you through grief, and I know that it's a part of your family. In law enforcement, I've worked with crime victims quite a bit, and one of the things that I had that I gave cards to my victims was the absence of their presence is everywhere. That's the thing about grief that just seems to not go away. So thank you for gathering the courage to speak on behalf of your brother today. All right, at this time, we'll go to Derek Johnson, the ADA for Rapides.
Yes, thank you. Derek Johnson, on behalf of Philip Terrell, 9th Judicial District Attorney's Office. Parole Board, we are still opposed to any condition, early release of Mr. Holmes. I do believe that it is important. I do understand that Mr. Holmes is making strides while he has been incarcerated, but I do believe that it's important for individuals to realize the consequence of their actions. As stated by the victim's brother, that was a life-changing decision when he made. I mean, we see that even in today's society when youngsters go out there and they take people's lives. He was given 2 pleas, one of 40 years and one of 55 years. And we at the District Attorney's Office believe that he needs to serve out his pleas. Those are the pleas that he was given. I mean, that was the time that he was given. That's the time that the family believes that he's going to be incarcerated for. And we at the District Attorney's Office, we're not moving from that stance right there. That's all I have to say. Thank you.
Okay, thank you very much for joining us today. Okay, at this time, your case was assigned to Mr. Danny Barra. He will conduct the interview and later he will cast the first vote. Mr. Barra?
Yeah, Mr. Holmes, what was your part in it? I know there was several co-defendants. What was your part?
My part, it was in the aspect of a group. My part, I shot Mr. Kevin Martin. It was designed for multiple drug deals, transactions. And we went in, one thing led to another. And as I spoke with earlier in the event, I thought he was going for a weapon and I shot him and fled out the door. It was several shots going on. I knew I hit Mr. Martin. And that's what I did.
It was 2 different guns. Were you shooting 2 different guns?
Sir, as I said before, I have co-defendants. At the time, I had a .380 automatic handgun. And that's the gun that I had. That's the gun that I shot. I have two co-defendants on this particular case with me. And the gun that I had was a .380 handgun.
All right. And what have you learned since being in jail? What have you learned about yourself?
Bro, just in general of me battling, I understood that going through everything that I put myself through, what the Martin brother, Kevin Martin brother spoke, and it's serious. And I can't take away how he feel, because he deserved to feel everything he felt. And I learned with me that the more I grow, the more I've matured, the more I understand the damage that I've caused. And man, it'll break you. And through God, man, through God, I understand. I never understand truly what the effect is, because my family, as he spoke, is here. I've learned that, man, I've destroyed because of my actions. I carry it. And I just find ways to stay positive and keep going to help other people.
Thank you. That's all the questions I had.
Ms. Ledoux?
I just for a point of clarification, was this a drug interaction? Was this a buy or sell? Or did you know that he had the drugs and you were just gonna go get them?
Yes, ma'am. It was a back and forth drug transaction by sale. And I knew he had the drugs, and I went to go rob him for the drugs and money. Yes, ma'am.
Okay.
Is that all the question, Ms. Ledoux? That's it, okay. Well, they have here that the .380 caliber weapon was shot 6 times. And then there were 2 shotgun slugs. And you're the one with the .380. Did anybody else have a .380, or was it just you?
It was me and Collins Mason. I know I released, I can't tell you exactly how many, I know I released at least 4 shots, and I'm not gonna say it wasn't 6. Me and Colin Mason and my other co-defendant, Walter Riley, I know I had a .380, and as I spoke, when I seen Mr. Martin make a sudden move, I released shots. I released multiple shots running towards the door. I know I hit him. I can't say how many times. That would be untruthful, but I know I hit him.
Well, it's very impressive. It's true. It's very impressive, all that you've done with your life. There's no doubt about that. You know, the old saying is you took the bull by the horns and you've decided to find yourself a different path. And that's very obvious from everything that you said. But on the other hand, you did see the grief from Mr. Martin. And it's true. You know, when I would have victims that somebody had been murdered, one of the cards that I had was, and it's true, the absence of their presence is everywhere. And that's why the mother can't sleep in that bedroom nearest the house. That's why the brother still remembers the high school picture. So that loss is when something special happens, they're not able to turn to that person and laugh with them and different things like that. And I'm sure you learned all that in your victim accountability classes. And then you made the plea bargain according to the DA, which was 45 years and 55 years. So what do you have to say about that? Because it's true, the victims that were in there that day, they do think that that's what your sentence was and what you agreed to.
Yes, ma'am. At that time, my lawyer at that time, this is what he brought to the table, and he told me it was in my best interest, and I'm not going to say it wasn't. Not knowing the system young, and just really didn't even know what I was getting myself into in that aspect.
Yes, sir.
When he brought it to me, I just wanted to get it out of the way. I didn't want to prolong nothing with my family. My grandmother was the elder. I didn't want to prolong nothing with the Martin family. And I was because I didn't even want to face nobody in person. And that was the cowardice and weakness in me. And I took that.
Cowardness, I think that's kind of just where you were at the time. I've seen that too. I've been in a lot of courtrooms with this type of thing. So Anyway, so I think we've gotten everything you need to say. Do you have another final statement that you'd like to make, sir?
Yes, ma'am. I know sorry will never be enough to fill the void that I've caused in the Martin family life. And man, I pray and just hope that it gives them some type of consolence to consider them to know that I'm dedicated, not only to do the right thing, but to help others not make the same decisions that I've made to cause other people to be victimized and trauma reporting other people's lives. And I just ask that, they know that, man, I'm moving forward, and I just want to, I'm sorry for what I did.
Yes, sir. Well, I can see your remorse. So at this time, is the board ready to vote, Mr. Barra and Ms. Ledoux?
Yes.
Ms. Ledoux? Okay, Mr. Barra, you have the lead in this case, so you would vote first, please.
All right. Mr. Holmes, congratulations on all the programming and all the stuff you did to change yourself while you're there. You're doing a good job of that. But I got to tell you, when the lawyer told you it was in your best interest to take that plea, he was 100% right, because what you did was a first-degree murder during the commission of an armed robbery, which is one of the probably the most serious crimes you can commit. And you agreed to that plea, and you just haven't served enough time yet. You've done good work in jail, and good preparation to get out, but today's not your day. I cannot grant parole to you today. I vote to deny.
Okay, and Ms. Ledoux?
Mr. Holmes, you present a very difficult case because you've done everything that that we would expect an offender to do to prepare for reentry. You have good plans. However, today is not your day for me either, and my vote is to deny.
Okay. Well, Mr. Holmes, I agree with both of my colleagues. You did take a plea bargain, and like Mr. Barra said, had you gone the other way, it would have been life. So you haven't served enough time on that for me to be able to grant your pardon today. So my vote is to deny. So that concludes our hearing with you this morning, and it is 10:15.
Denied.
Given the execution style factor of that case, not overly surprising, to be honest with you. Let's go to Judge McNally. We haven't been there yet this morning. Let's say good morning to him.
Need probation. Okay. Morning, your name? You pled guilty to, good morning, your name? You pled guilty to disorderly person public intoxication. This is from an incident that occurred on July 26 or 25. You pled guilty on October 2. You were referred for a screening and assessment. Maybe, first of all, before we go on, I want to remind you have the right to an attorney. If you cannot afford one, I will be happy to appoint you one at public expense. Do you understand that? Would you like an attorney to represent you? I can't hear you, ma'am.
No.
Did you review this pre-sentence report, the screening? Is everything in this report accurate?
Yes.
And you saw the recommendation, correct?
Yes.
Is there anything you would like to tell me before I sentence you here?
Well, right now I'm just currently expecting, and I don't have like transportation, so if I do have to do like
I can't hear you, ma'am.
I said right now I am expecting, and I don't have like a vehicle, so if I do have to do like the blood testing, it might be a little bit difficult to like get there.
You live in Flat Rock, right? Yes? Okay, so I'm just telling him in order drug testing, and I expect you to show up.
Is it here?
It's right down the street, though. They'll set you up at DMA. All right. How much did you have to drink that day?
Like 9 shots, I want to say something.
9 shots?
Yeah, it's like, probably like little green tea shots. It's just like a bunch of things together.
You got to keep your voice up for me, okay? Is there anything else you want to say? 9 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to order that you submit the chemical testing, PBTs and ETGs. I will do that on demand. You scored in category 1 on both the alcohol and drug use. Tells me you don't have a problem. But I am going to order anger management weekend program, okay? I'm going to order that. You're not to have any contact with the victims in this case. Do you understand that? All right. Also, I'm going to order, still want you to go to the Alcohol and Drug Insight and Awareness Program, okay? So you attend those. And I'm talking about the Anger Management Weekend Program, the Alcohol and Drug Insight and Awareness Program. No contact with the victims. No alcohol, drugs, or marijuana. Chemical testing on demand. Do you understand all of that? I'll order 2 days of community service. I'll give you a lot of time to do that since you're pregnant. December 15th to 25, okay? $100 fines, 100 costs, 75 victim's rights fee, $50 justice assessment. Screening fee is $60 for 385. You also have probation fees of $180 for a total of $565. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that? I'm going to give you a review hearing date in 9 months. You're going to come back then. If you've complied, the prosecutor will move to dismiss and I will go along with it. I am taking this under 771.1. So I will need one. Next time you got to come without the child though, okay?
And she told me just to come with my baby, not just like.
Well, I mean, that's nice, but. Okay, so give me a date in late June, or early July, Heather, please.
That will be, we could do
What?
June 20, I'm sorry, this is fire, June 26th.
At 8:30 in the morning, okay, ma'am? So June 26th at 8:30 in the morning will be your review hearing date. Can you pay all these fines now?
Not now, no.
How much do you have today? And you are just, how are you supporting yourself? You get $100 weekly in shelves?
Let's stay at home. I just get support from my transfer.
Tell me how much you can afford to pay weekly or bi-weekly, whatever you choose. Weekly or bi-weekly? $50 bi-weekly, and I'll start that beginning October the 24th, okay? Now, if you need more time, you come into the court or call. We go on Zoom, you and I, and I'll be glad to give you an extension on it before any due date. Just don't ignore me, okay? All right, so you're going to go meet with probation. They'll go over the order with you. Do you fully understand everything? Okay, good luck. Thank you. Dylan Ray Bemis at 25R514250. Good morning, Mr. Hall. How you doing? Good?
Doing very well, Judge. Great to see you. Joseph Paul Greenfield on behalf of Mr. Bemis, who stands to my right. Mr. Bemis, you can say your name to the record. Dylan Ray Bemis.
Good morning. So this is going to be a plead up operating while impaired. I know he signed one before.
He did, Judge. We do have one in the file. If you'd like.
I still want another one.
Absolutely.
Otherwise I have to verbally acknowledge all the rights here. Mr. Demus, take your time and review that and make sure you understand it, and then you can sign it and we'll go from there, okay? All right, so if you plead guilty to operating while impaired, I want you to understand that that is punishable by the following: up to $300 in fines, 93 days jail, 360 hours community service. Court costs are all those. Do you understand them?
Yes.
4 points will be added to your record and your license will be suspended or revoked in accordance with your record. Do you understand that?
Yes.
Okay. Catherine Kuykendall, you can have a seat right at the table up here, please. Catherine Kuykendall can have a seat at the table.
Judge, would you like me to fill out the address?
Nah, that's okay.
May I have those?
Sure, thank you. You sign and read and understand that advice of rights.
Yeah.
If you plead guilty, you will be giving up all those rights and there will not be a hearing or a trial. Do you understand that? Okay, you understand all your rights.
Yeah.
To the charge operating while impaired, how do you plead?
Guilty.
On July 26 of 25 at 12:24 in the morning, were you operating a motor vehicle on Huron River Drive near 4th Street in the city of Rockwood, County of Wayne?
Yeah.
Prior to that time, did you drink alcohol? And if so, what?
Yes, I did. I got beer, can't cause it, and how many? I don't, sorry. Soon, at least 5 to 6.
5 to 6 beers?
Yeah.
Was your ability to operate the motor vehicle impaired due to the consumption of that alcohol?
Yes.
In what way?
Reaction type of.
No, why were you pulled over by the police?
Because I ran a red light,
You think you did that at least in part because of your alcohol consumption?
because of the effects of alcohol consumption, yes.
Was this an intoxilizer or a blood draw?
It wasn't intoxilizer, Your Honor. I'll stipulate for the record, 0.128.131 was all.
Okay. And are you on probation or parole, sir?
No, I'm not.
Anybody force you to plead guilty?
No.
All right, I'll accept the plea. I find it to be an accurate plea, made voluntarily and understandingly. Please accept it. The operating while impaired. The OWI I'm going to dismiss, refer you for a screening and assessment. So you'll fill out a questionnaire today. You'll be interviewed today, and then you'll come back for sentencing. This is a first offense?
It is, Judge.
Okay. What date do you have for us, Heather?
That will be October 30th at 9:15.
Is that good for you, Mr. Hall?
Your Honor, unfortunately, I have an evidentiary hearing at 9 in Washington.
That's no problem. What other date can you give me?
November 13th at 9 o'clock.
Oh, you know what you could do for me? Oh, you can't do it. Yeah, October 30. Okay.
Judge, unfortunately, on the 13th.
No.
On the next date provided, I have a probable cause conference and a homicide in Washington County.
Just give me another date if you would, Heather. It doesn't have to be on a Rockwood docket day. There's no restitution here. No accident, right?
No accident, Your Honor.
So we can do it any day. We can do it on a Monday.
Okay. How about November 10th?
How's that look?
I have a Zoom. Yes, I can do that, Judge. I have a Zoom at 10, but I'll be able to work around that. I can do Zoom from the courthouse.
Why is everybody talking loud back here today? Guys, come on, please. November 10 at what time?
We could do 8:30.
Is that good with you? You got a long way to trek. If you
I'm always willing to wake up early.
8:30 in the morning, November 10th. Okay, good to see you, Mr. Hall.
Great to see you, Judge.
You go across down the hall, get your notice, and then over to probation. Okay?
And Judge Vincent said to say hi.
Yeah, give him my best. Will ya?
Great to see you.
You know, his buddy not doing real well. You know,
Yeah.
it's terrible.
Mike and I've been talking about it. It is terrible.
It is.
Tough one.
Take care of yourself. Good to have you here as always. Tahir Ali, 25I-414-806. Is Tahir Ali here? Good morning. Your name? Okay, so you got a show cause for failure to pay. Why haven't you paid this?
Your Honor, it had to come to my address. The letter, so I wasn't aware. I remember that.
They gave you the ticket, right?
Wait
Wait a minute, slow down. I get so tired of hearing that.
No.
He gave you the ticket, right?
Correct.
Did you call the court?
Yeah.
You called the court? When did you call the court?
That's scheduled appointment.
Listen to me. I want to know when you called the court.
7 days after.
And what'd you tell them?
I told them, could I schedule an appointment? They said I have to go through the online. But I said like an online portal where you're supposed to go schedule an appointment.
Is that true? Am I learning something here today, Amy? He's saying you gotta go on an online portal to schedule an appointment. Is that true?
No, we transfer them to a voicemail where he leaves his message, or they can go online.
Well, did you schedule an appointment?
No, that's the thing.
Why didn't you do that?
So I'm a delivery driver. It's not an excuse, but while I was getting a call right after and confusing me, and I just stuck my mind after that.
All right, so you called, they told you what to do, and you didn't follow.
100%.
This was 4.5 months ago.
Yes.
Okay, I slowed down. Write this down when you get out to your car. You cannot ignore courts. Write it down. Put it in the blackboard of your mind. How much do you have today?
Yeah.
When are you gonna pay it? You should have been asking me for this 4.5 months ago.
Just my address may have the wrong address now.
You didn't schedule your appointment.
No, I'm good. Like it's on me, I need to send notifications, like the local computers.
Tell me how much you can pay. Rick.
Weekly, you said?
Yep.
25,
How much do you make as a delivery driver?
about 1,000 a week.
You want to pay $25 a
I
week?
just got married and my wife's pregnant.
You have medical insurance? You got to be more responsible. Pay $25 per week, and I'll start that beginning October 27th. If you don't have $25 on that day, you call the court, we'll go on Zoom on or before that date or any other date, and I'll be glad to give you an extension. Stop ignoring court, okay? Got it?
That's it.
All right, you understand me? Good. Good luck. Pauline Patty Bozan, 25F244656. Oh, this one isn't up yet. This case isn't up here yet. This was scheduled for 9:30, right? Your name?
Yeah.
Yeah, it's set for 9:30.
I thought that said 8:45.
It's 9:30, so I have to wait to call the case. Okay, thank you. Kuykendall, Catherine Marie Kuykendall, 25W839197. Your name?
Yeah.
Where have you been? You gotta show up. You gotta talk to us. How much do you have today?
I pay until tomorrow.
How much can you pay tomorrow?
$50.
A week? Can you do that? You pay $50 bi-weekly beginning tomorrow. Can you do that?
Yeah.
Now, if you don't have the money, you call the court. You can go on Zoom with Judge Hessen and she'll give you an extension, all right? Just don't ignore us. Good luck. Thank you.
All right, let's change things up a little bit. Go down to Texas, 9 to 11% more. Judge Boyd, we'll say good morning to her.
CR 003006, State versus Chase Anthony Lopez. Can I have parties announced for the record?
Melissa Alvin for the state. Caitlin Knowles for Mr. Lopez.
And are you Chase Lopez?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lopez, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Lopez, did you review the court's admonishments with your attorney? Did you understand it, sign it in all the appropriate places?
Yes, ma'am.
You're charged with collision involving injury as a Class A misdemeanor. At least that's how the state is proceeding. The range of punishment for that is up to 1 year in the Bear County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. All right, off the record. So is this an application?
Yes, Your Honor, for deferred adjudication.
Okay, I don't have an application.
I want to fill it out unless it's.
Okay, let me see. Maybe it's stuck to a staple. Okay, just 1 second. It's stapled to the acknowledgement of discovery. All right. Thank you. No. Did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it? Do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? You're gonna need to speak up.
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to a year in the Bear County Jail and up to a $4,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering into a plea, you could be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a $1,500 fine, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 80 hours of community service restitution, no contact with Aaron Dabney and Skylar Henderson, MRT, no alcohol. What is this? Alcohol consumption. If you're placed on probation, you're not allowed to drink alcohol at all. You understand? ETG and regular UAs and the driver's safety course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers in evidence, states exhibit 1 with its attachments. No objection, Your Honor.
And state, is there going to be any requested restitution or no?
There is not, Your Honor. The victim did not have any.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, we're gonna waive any PSI, but we did have a couple things that we'd like to bring to the attention of the court.
Yes.
With regard to community service. My client works over 60 hours a week. He just got promoted to supervisor. He's going to do everything that he can to keep his nose clean during probation. We're asking that you probate at least some of the community service. And then I don't believe he's a great candidate for the MRT. MRT is for those who have a series of bad decisions and how it affects their loved ones and how they can turn it around. My client, as you read in State's Exhibit 1, literally was just disoriented and scared at the time of this offense. I don't believe perhaps the court would like to revisit that at another time. That's fine too, but we're asking the court to remove the MRT and at least probate some of that community service, Your Honor.
All right, why did you leave the scene?
To be honest with you, I don't know.
I'm sorry, what?
I don't know, ma'am.
I mean, well, it says in the police report that your mother convinced you to go back. How old are you?
28.
28?
Oh, I'm sorry, 29.
29. So you were probably 28 when this happened?
Yes, ma'am. That was
So why did you leave the scene?
I don't know. Panic. Really all I could say.
I mean, I could see this if you're a teenager, okay, panic. If you would have stayed at the scene, this is just an accident.
Yeah.
It's not a crime. So I don't understand why you would leave.
I was exhausted. I've been doing this type of work for over 2 years now.
What type of work?
I am a foreman for a construction site. We do fiber optic cabling for data centers. It's a lot of stress involved. Timelines get pushed forward. A lot of stresses on that. At the time I was working night shift, same as right now. I got like 2 hours of sleep before I came here. I'm used to running on E a lot of the time and it caught up with me. That's what happened.
Right, but you do understand that the fact that you are tired, the fact that you work night shift has no bearing on not stopping to check on somebody to see if they were injured from an accident.
Moment of impact to the time of me getting in the cruiser with the cop. I had just gotten in the impact. I fell asleep behind the wheel. As far as between that moment and me getting in the cruiser, honestly, as disoriented as I was, I couldn't tell you what my thought process was.
Yes,
I mean,
back
but you-
deployed, and he has diagnosed anxiety as well too. So that
Well, maybe he shouldn't be driving, because here's the thing. You knew enough and your mom knew enough to say, hey, you need to go back to the scene of the accident. So unless your mom is clairvoyant, she knew, you told her, hey, I'm in an accident. Or she said, hey, what happened to your vehicle? And you told her you were in an accident and you had to have told her the location, because how else would she know to tell you to go back to the scene of the accident? So I don't know if you should be driving. So tell me why you should be driving.
It's the only way that I'm able to get to work. I've had no accidents before this. As I said, I was exhausted. I fell asleep behind the wheel. As far as the cause of the accident, that's what it was.
Well, see, here's the thing. The big issue, honestly, is not the fact that you had an accident. That's why people have car insurance, because you may have an accident.
I should have stayed after.
Yeah.
It's plain and simple.
And the reason why I'm asking you these questions, because I'm trying to see if MRT is appropriate for you or not.
would you tell the court about some of the things that you've done since the accident that to demonstrate to the court that you understand the mistakes that you've made and changes that you've made in order to better understand and get along in society without being reckless or neglecting others?
As I've gotten promoted recently, trying to build a community and working with coworkers and understanding the trials and issues that my other coworkers have. I try and work with people and understand them on a deeper level. And right now that's what I'm working on, is my leadership skills and leading by example. And right now, that is not something that I want anyone else that I lead to do, let alone myself. That is not something that should happen.
Probation with regards to MRT. Do you think that's appropriate in this case?
Why don't we hold it in abeyance for now?
Okay. Thank you. There's going to be 2 years deferred adjudication, regular reporting by Zoom or in person. regular random UAs, or you can do the patch. The patch costs more, but it allow you to be at your work. With the patch, they'll put it on you. You're not allowed to remove it. They'll remove it when they'll give you a date to come in to have it removed. Field visits 1 time per month for 2 months. Proof of employment within 40 days. No employment as a home healthcare provider or with minors. And my understanding, Ms. Abrams, there's no restitution that is due.
That's correct.
All right, there's going to be the driver safety course. 80 hours of community service restitution. With regards to the 80 hours of community service restitution, you will either do those 80 hours or either you can write a letter to the complainant in this case, expressing your dismay and expressing your apology to that person. You understand?
Love to do that.
I'll take it and give it to you because you're department contact.
Okay, and that's to be 80 hours community service restitution, other letter to Aaron Dabney. State, with regards to this no contact order, I don't know how he does that when people are driving on the road. He's not going to know if the person. So I'm not inclined to issue a no contact order.
That's fine. I don't believe they have any personal knowledge of or personal relationships with each other. Obviously, this was a car crash, so I don't think it was coincidental or anything that they knew each other. That's just, standard recommendations.
All right, thank you.
That's fine.
Probation, does he need the driver safety course?
Yes, sir.
All right, and then the driver safety course. Oh, thank you. No. Is there anything else, probation?
No, Judge.
Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, accidents are accidents, and they're called accidents for a reason. A lot of times if people would just stay, even if you have an accident and you don't have any insurance, don't leave, because then guess what? Now you got an issue with not having insurance and you have a felony charge. You understand?
Yes, ma'am.
All right, once you go over conditions with probation, you're excused. Good luck to you.
Thank you, Your Honor.
Thank you.
All right, let's head back to Louisiana and give them a second try.
I will serve as chairman on today's panel. My colleagues are Jerry Ledoux and Danny Barra, and they will be joining us on Zoom. My location is DOC headquarters in Baton Rouge. Today's remote location is Raymond LaBorde Correctional. And staff, the warden's already introduced himself earlier. So Mr. Pryor, would you please introduce yourself with your name and your DOC number?
Name is Ed Pryor Senior. DOC is 544462.
Okay, I'm going to read the information from your master record on the record. Your name is Edward Pryor. Your DOC number is 544462. You're a first class offender. Your parole eligibility date is 4/11/2017. You're not eligible for good time. Your full-time date is 10/24/2035. You have a total sentence of 30 years. And this, your sentencing date was on 10/8/08, and it was for incest. And first count was 15 years. The next count was 15 years concurrent. Then you had another one of 15 years consecutive. And then the fourth count was 15 years concurrent. Is that correct?
Yes, ma'am.
Okay. Okay, well, you tell us in your words why you're incarcerated and why should we be releasing you early today?
The reason I'm incarcerated is because of my bad habits and the thing that I inflicted on my family with that incest. That's why I'm here. One thing I am about, want to say is that what I did was incomprehensible. I didn't destroy somebody strange. I did it to my own family. That wasn't right. In fact, it was very evil. I had just made a serious blunder in judgment and things, no matter what I did. It was my decision. They were terrible, and I really regret those decisions. That's why, as long as I've been here in Raymond LaBoard, I've been changing my inner man. It has to be changed. Because a superficial change ain't gonna do anything. I have to change me. And I've been doing that for while I've been here. And not only have I been changing me, I've been helping others to make the same change. Because the things that we come in here for, especially me. I was a minister on the street, and I can't believe this here. But I did it. Am I proud of it? No, man. If I could talk to my children, because I lost all of them, I would tell them how sorry and deeply sorry I am for what I've done. I can't change that. I wish I could, but I just can do it, just say I'm sorry. Now, since I've been here, I've been taken a lot of classes that helped a great deal. The last class I took was time. Oh, that class, and part of it, I had to look in the mirror. That rascal, excuse me. When I had to stand up and look in the mirror and talk to myself and deal with me was a hard part, but I learned some things. Even though I did these things, I take these failures, they're not fun, and turn them into a lesson. I teach that all over this county, especially about a father's business, where how you're supposed to raise his child. I made a statement last time I was on the parole board about a young girl in Shreveport who talked about his voice. I had to learn that voice. A man has a strong voice in his family. He could either make that family or he can destroy that family. My voice, I didn't understand it. My wife introduced me to it and said, "I'm trying to pay attention to you just by what you said." I still didn't understand. I wasn't raised by no man. I was raised by my mother. She did a fine job. My aunts and my grandma. But I didn't understand that voice. And so I started preparing myself, wherever, even in here, teaching the classes, especially when I'm talking to men and young men. I say, you have a strong voice in you. I messed mine up and I said it just like that. But you have a strong voice in your family that can either make your kids succeed or be failure. Now, I asked my two daughters to go and make sure to get a college degree. I was in a mechanic and I was trucking business. And they still grew up because they still have those same dreams because they in the truck. So I recognize that voice is strong. But I messed up, man. And it was just something that Lord, I regret.
Let me ask you, you took a plea bargain because there was forcible rape involved in some of your charges as far as the plea bargain. So you served about 17 years of the 30 years. So why should you be released early?
Now, I'm asking to be released. If I'm not released, ma'am, the pride of I done really changed. I'm not the same man. I'm not the same man. I don't walk around here trying to help other people, kids, through this system and teach them the right way to live and not change myself. I had to change. When I was back there, that was stupid. That was ignorant. That was foolish. It was dangerous. I heard one of our, they were told me about my daughter had to take pills and everything else for a mental condition. That bothered me. That tore me down. I had to do this and then realize what I did was real bad. You won't let me go, I would thank you, but if not, I still have to face what I did.
Well, you know, that's a major betrayal for a child.
It is.
And for them, generally, they don't get that back in their life, that trust. So it's something that they fight with all their life. Warden, do you have anything you'd like to say, please?
No, ma'am, no comment.
Okay. How about any courses that he's taken? Any pre-release, anything like that, sexual assault?
Yes, he has. He's taken several courses, victim impact, thinking for a change. He's completed all those. He's taken several courses. He applied himself in any class possible here at RELCC. He's done them all. He's
Pre-release? He's taking pre-release, he's taking pre-release?
Yes, he has. He has.
Okay. Okay, I didn't mean to interrupt you, Ward. Anything else you'd like to add?
No, ma'am. No, ma'am. Not at all.
We have someone here in support for you on Zoom. Her name is Courtney Moses, and she's a friend. Would you like to speak, please?
Yes, how you doing? Mr. Courtney Moses. How you doing? So yes, I want to speak on behalf of Mr. Edward Pryor. Can you hear me?
Yes, sir, I can.
Okay, yes. I didn't, first of all, thank you for having me to speak on the parole board today.
Yes, sir.
Not even 3 years ago, I sat in the same chair that Edward Pryor sat in the same facility. And I don't know Edward Pryor prior to 2016 when I met him. I can only attest to the 6 years that I spent around Mr. Pryor. I came to RLCC, and like I said, in 2016, he has been a mentor to me. Mr. Pryor, Mr. Pryor is the only man. I was incarcerated 26 and a half years. Mr. Pryor is the only man, and I'm not saying this because I was formerly incarcerated, I'm telling the truth, man. That's the only man that I knew that had respect from everyone around him. If I can describe Mr. Pryor in one word, it could be consistent. He helped me realize my purpose through examples, through small examples that he would set on throughout the compound, just being consistent. I watched this man break up gang fights because his presence alone commanded the young man to listen, to pay attention. He's a difference maker. I don't know what happened as I listened to Mr. Pryor, and my heart hurts for the victim because no one deserved that. But I don't know him prior to me meeting him. But from the time I met Mr. Pryor, he's the reason why I adopt a lot of my principles today. And I'm speaking on behalf of Mr. Pryor because I strongly feel that he deserved to come home to live out the rest of his life and live out his purpose. He wants to change. He invests in people, man. The Warden Thompson, no one can really have a bad word to say about Mr. Pryor because he's consistent. Is this not a game? You can actually, we was trained to be game players. We know BS. I ain't no BS. This young man is not BS, and he really loved the Lord. He really have a heart to change. Currently, I'm a workforce development specialist at Job 1 in New Orleans. I prep people to get careers to make over $50,000 a year. I help people to launch their careers. And And I can assure you, ma'am, if the board release Mr. Pryor, he's not coming home to family. He's coming home to a community of brothers like myself, who have resources to assure that difference makers like Mr. Pryor, that we know that will be a difference maker, will have the house that he needs, the employment that he needs. I will help him with employment. I work at a resource center, man, and I will exhaust every remedy that I can to assure that Mr. Pryor receive his, to assure that to assure his success. And I just ask that y'all give Mr. Pryor a chance, because this man really deserves it. I'm trying to be strong for him.
Interesting. Well, you have your relationship with him, and so did the other people. And so thank you very much for joining us today and speaking in his support. Okay, we don't have anyone in opposition here today. The case has been assigned to me, so I'm going to conduct the interview, and later I will cast the first, okay? My interview is, I heard your remorse, and I hear all the good things you do with other people, but it's a different type of crime. Usually the person is, for other people, a different type of individual, but you are actually a child predator for your daughter. And I guess you can agree with that, because that's basically what you understand, Mr. Pryor. Am I correct?
You correct?
Yeah. According to what I've read, this started when she was about in the 3rd grade. Is that correct? Or was it earlier?
I think about when she was about 5 years old.
About 5 years old? The thing about this type of crime is some people, and you didn't do this, you didn't use the excuse, alcohol or something like that. Because I tell you what, you can lay a child buck naked in front of somebody falling down drunk, and if this is not in their mind to do, they could not possibly have sex with a baby. It's just not even going to be possible. So like I said, it is the ultimate betrayal, because you were her father. It's usually a trusted individual. It'll be a grandfather or grandfather figure. Sometimes they'll say, oh, she jumped up in my lap, this kind of thing. You're responsible for how you portray that act in your mind, because that child is just being affectionate like all children are. So how do you think this started with y'all? She's 5 years old.
Ma'am?
Yeah.
Decisions on my part.
Pardon?
It was bad decisions on my part.
Okay.
I had a marriage that I thought was perfect. But I come to find out what it is. It's not an excuse. Someone had to learn. I'm not making excuses, because it was just a bad decision on my part. I didn't want to break up with my wife, because I love her. She's dead now. I didn't want to break up with her. But she's a good mom. But she wasn't a good wife because of it took me a while to learn this, of course, because of her sexual preference. And it wasn't for me. Took a while to understand that. I loved them more than I loved anything. In fact, I loved them more than I loved my children. And that wasn't right. That's why I talked about being a father. I did some serious damage there. I don't care what my wife was doing or what anybody else was doing. I did that.
Well, I can understand that better if your wife was a bad wife and you saw somebody outside your marriage that was your same age, but not the child that was 5 years old. That's two separate things. It really is. It has nothing to do with good marriage or bad marriage. It's the ability to make that decision. Let me ask you something. I did read in here, were you a minister? Did you tell me that? What was your job?
The minister on the street, I'm still a minister now, man.
Okay, so you were a minister. Now, there was some conversation that maybe you used the Bible, you would quote the Bible or something, justify your behavior?
Well, that's the way she said it. I wasn't justifying my behavior.
Oh,
My daughter was getting out to the streets, and I planted those seeds in her. And she started laying with everything. That's my fault.
yes.
Can't do that. I messed you up. I told her that.
Yes.
I told her that. I'll mess you up. And I wanted to get out of the streets.
But it continued on into her adulthood, though.
Yes, it did, because some touchy stuff. The reason why I continue on, she came to me one night and said, Dad, I can't. I said, because I had told her, I said, if you don't get out of the streets, age was just starting up. I said, you're going to run catch something you can't get rid of. I told all this.
Uh-huh.
I told her about the age that continued. There was no pill. There was no pill you could take at that time.
Yes, sir.
I said, you just messing with all this guys, you're gonna wind up getting something you want. If you can't, if you needed help, come to me. And she didn't come for a few days, and one day she did. So I responded to that. Because I told her, don't go out there. Because I hadn't stopped that mess. She never put that in the record, and I'm not down in my daughter. She doing
Yes.
I'm not down in, I love my child.
Yeah.
Oh, children. I just had to get myself out of a dark situation that I couldn't have.
Yeah, I think you didn't get yourself out of a dark situation. I think you got arrested because you got told on. Now you're out of your dark situation because you don't have any choice.
Ma'am, I changed myself before I got arrested.
Oh, okay. Well, that's good then. So listen, Mr. Barra, do you have any questions? No? Okay. No questions, Mr. Barra?
No questions. You covered it pretty good.
Okay, Ms. Ledoux, do you have any questions?
I do not.
Okay, well, closing remarks, sir. What would be your closing remarks before we vote?
I'm just gonna ask you for another chance, because like I said, I really regret what I've done. Like I say, it's incomprehensible. I shouldn't have done it. I made a mistake, made bad decisions, main thing. And it was very destructive to my child. I prized that girl when she was, but it's just things I just wasn't thinking straight. Just wasn't thinking straight.
Okay, is that your closing remarks, sir?
Yeah, and I would ask you, please give me another chance to work in the community. Because the biggest problem I find out, young men growing up, especially in here. My first question I asked, where your dad at? Well, I don't know. Oh, he left me when I was young. So I've been training, I've been acting like a father to these guys in here because that's what they need. When a young man grew up like I did without a father, you really don't know how to deal with it. You really don't. I had to learn that here. And I just wish, I pray to God that y'all give me a second chance. There's no way I'm coming back here. But I would like to come back and keep teaching because I have a heart here. In fact, I stay in Cajun. I stay down there. That is the longest walk on this compound. And I stay down there because I help the young men down there and give them a father figure, which they don't have. I have a lot of young men. I ask them too, where your dad? Well, a couple of them call me, you my dad. I know it. My mom said, my dad is in prison. I'm not his dad.
Okay. Well, it sounds like maybe, sadly, you're serving out time with your calling, because that may be your calling to help where you're at. So I'm ready to vote at this time. And my vote is that, I'm gonna deny your parole. You've only served, about half of your 30-year sentence, which was a plea bargain, because you had many cases of incest and forcible rape. So you got a deal on that instead of probably life. So my vote today is to deny based upon lack of time served. Mr. Balrock, what's your vote?
I'm gonna vote to deny based on strong law enforcement opposition and multiple crimes committed over a period of time against a juvenile victim.
Okay, Ms. Ledoux?
My vote is to deny based on the nature of the crime.
Okay, so today, sir, your parole has been denied, and it's based on the nature of your crime, that it was multiple times. It is strong law enforcement opposition, and I feel like you haven't served enough time of your sentence. So that concludes our business at 10:45.
Thank you.
Denied.
So thank you, Michael, for clearing up that that you tossed your headphones on the keyboard, because I spent a couple of minutes trying to decode that message that you sent, and I couldn't make any sense of it. Much like I can't make any sense out of this hearing. The thing that struck me most was towards the end when he said, "I'm acting like a father to the guys in here." Based on how he already acted as a father, I feel very bad for those men, because Lord only knows how he's quote unquote acting like a father with them. Not a good situation. Let's finish up our day with Judge Boyd.
Court is calling 2025 CR 010839, State versus Lavelle Lemons. Can I have parties announced?
Megan Galloway for the state.
And for the defense?
Julie Pollock for Mr. Lemons.
And are you Mr. Lemons?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Lemons, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are waiving the elderly enhancement and proceeding on the Class A misdemeanor of assault bodily injury.
Any objections?
No objections.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You understand the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am. He confers with me.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he was.
Mr. Lemons, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of assault bodily injury. They're asking that your punishment be assessed at 9 months in the Bexar County Jail. There's an $800 fine. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, ma'am.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and cite it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Council, are there any such motions?
No.
Outside the agreement, the state is requesting that there be no contact with George Shelton. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State any evidence?
State offer states one in attachments. No objections.
Did you review the waiver? Oh, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
No, ma'am, we would just ask that you follow the plea bargain in this case.
All right, and I see that both of you are elderly. Why? What's going on?
Misunderstanding, ma'am. Just a misunderstanding between us.
Well, no, here's the thing. You can't be the spokesman for other people if they feel that someone owes them money. That's not your place. Now, the state, I'm assuming they're proceeding on the lesser included offense because honestly, the injury to the elderly, I think that's really was meant to anticipate younger people fighting the elderly or abusing the elderly, and not for 2 elderly people. So,
Not going back to that assisted living place. He'll be finding he's been incarcerated for quite a while.
okay, and was that the that place, is that the Fair Avenue Apartments?
Yes, ma'am.
And have you removed all your stuff from there?
No, ma'am, I've been incarcerated ever since that happened.
All right, so here's the thing. If you want, or you have items that need to be removed from there, I'll allow you to go back there with a police escort only. You understand?
Yes, ma'am.
All right, the court is going to sentence you to 9 months in the Bexar County Jail. There's an $800 fine. Time and money will run concurrently. Give you credit for any time served. There's to be no contact with George Shelton, no contact with the Fair Avenue Apartments without a police escort. And how much time does he have in?
I believe he has 125 days today.
Okay. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
You're welcome. Thank you.
Thank you.
Okay, friends, that brings it to an end for this episode of TCF Live. This was episode, number 150, 155 maybe? I'm losing track. 156 today. So I hope you all had fun. I know I did. We'll be back tonight, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar, so be sure to join us there. And we'll be back tomorrow morning, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members, again, for this morning live show on Super Friday. We don't do regular Fridays here. We do Super Fridays. Appreciate every one of you. Thank you so much for tuning in, for all the support, for everything you do for me. Very much appreciated. Go have yourselves a great Thursday until the next time we see you. And oh, by the way, good videos posting today. So check those out. There's 2 that post, 1 in an hour, 1 in 3 hours after that, and both of them are great. So make sure to check them out. Take care. God bless.